the formal charges and hearing in Judge Williams' matter, and just for the record, it is Supreme Court docket numbers S24Z1139 and S25Z0722. My recollection is that we left off, I believe, in Judge Williams' case in chief. So we are ready for your next witness, Ms. McFadden or Mr. Banks.
Judge Williams, you call David Summerlin.
Okay.
You ready? Want to swear the witness?
Please.
Do you swear or affirm that the testimony that you are about to give will be the whole truth?
I do.
Would you please state and spell your name for the record?
David Summerlin, D-A-V-I-D, S-U-M-M-E-R-L-I-N.
And pardon me, good morning.
Good morning.
Where are you employed, Mr. Summerlin?
I'm employed by the Superior Court of Fulton County.
In what capacity?
I serve as a district court administrator, but also as the court administrator for Superior Court.
How long have you served in the capacity as the court administrator for Superior Court?
About 5.5 years, going on 6 years.
And what was your role prior to that?
I was a deputy court administrator in the same Superior Court.
Same Fulton County Superior Court?
Correct.
And how long did you serve as deputy court administrator?
Approximately 10 years, from 2009 to about 2020.
So is it fair to say you've served in Fulton Superior Court for 15 years in an
Yes.
administrative role?
Yes.
Okay. So, Mr. Summerlin, would you please describe for the panel your primary responsibilities in your role as court administrator?
As court administrator, I support, myself and my staff support the 20 elected Superior Court judges. We also have a host of programs and offices within court administration. For example, accountability courts, we staff the accountability courts. Other areas of operation, the the Justice Resource Center, which is like a law library, the jury services, all of those various functions for the court.
Okay.
Mr. Sherman, is that microphone off by chance?
Testing, yes.
Thanks for making sure.
I'll get a little closer to it.
Thank you.
Mr. Summerlin, I want to clear up something that you just said. You said you served the 20 elected judges. Not all of them had been elected, right?
The 20 Superior Court judges, which could be elected or appointed,
Okay.
otherwise appointed.
And who do you report to?
I report to the Chief Judge of the Superior Court, and I also, of course, answer to 19 other judges.
Who is currently the Chief Judge of Superior Court?
Ural Glanville.
Do you have any concerns today about how your testimony might impact your job?
No.
Who reports to you, Mr. Summerlin, in your role as court administrator?
In court administration, we have about 200 staff, but those staff are managed. They support the various programs and offices I just described, but they're managed through a series of deputy court administrators. I have 3 deputy court administrators who assist me in that endeavor, and I can speak to those individually or.
Just sort of high level, what are the functional areas of the 3 deputy administrators?
Okay. Heather McCants is the Deputy Director of Business Services, which is primarily the HR, finance, information technology, kind of the business side of the court, if you will. I also have Marlon Greathouse, who is the Deputy Court Administrator for pretrial services, case and court performance, which is part of our non-complex unit and our caseload data reporting unit. And Robin Cogswell, who is a Deputy Court Administrator who manages operations, which is providing court reporters, interpreters, making sure that the courtrooms have what they need and our facilities are well kept.
So let me start with the last point you made about facilities. Court administration has responsibilities for, with respect to facilities, offices for judges. Is that right?
Yes.
Okay.
Yes.
What are your responsibilities in that regard? Court administration,
If there are problems or issues, we have our building is aging, so if we have a water leak or an issue, something is in disrepair, we will handle that request. We facilitate it by working with the county's Department of Real Estate and Asset Management Department to ensure that anything that is in disrepair is taken care of. If there are other needs, furnishings, we will help facilitate the movement of furnishings or the procurement of furnishings for those spaces.
And does your office, in supporting the procurement of furnishings, support new judges when they come on board to the Superior Court?
Yes,
Did your office help Judge Williams in that regard?
we did.
Tell the hearing panel about the state of Judge Williams' facilities when she joined the court back in 2021.
The chamber space, I would say, was clean, but it was sparsely furnished, particularly in the judge's office, the main office of the judge.
Describe sparsely furnished.
I believe it was missing most of our judges, or all of our judges, have a conference table of sorts, and there was no conference table and there was no primary desk. There was just kind of an area where the computer sits, but not the main desk.
Would you have expected those items to be there?
Yes.
Okay. Why were they not there for Judge Williams?
I don't know. It's unusual, but for court administration, it can be a challenge because there's a lot of logistics that goes. I think several judges had left the court and several judges were coming in, and there were movements. So there were a lot of moving parts, and so I don't know why the furnishings were not there.
Okay. Did you accompany Judge Williams when she saw the space?
I did. I don't know if I was with her on the first day that she saw the space, but I was with her to see the space when we identified these issues.
Was there any reaction to seeing the space?
Yes. I was a little embarrassed and disappointed that we did not have a better space for the judge starting out in the new role.
Why would you be embarrassed by that?
Because I would consider those basic necessities, and they were just not available in place on the day that she started.
In your experience with assisting with facilities, have you ever seen a new judge's chambers be as sparsely, have such sparse furnishings?
I don't recall seeing a space that was that sparse.
Who was responsible for making sure that office was set up for the judge, the new judge?
There are staff who report to me who manage facility requests. When we have a judge that leaves, and we had 2 judges that left around this time, when we have judges that leave, our existing judges are able to move. They're able to move. So depending on seniority, judges can, if there's a vacant office space, they can determine that they want to move into that space, which will vacate their space, and so on and so forth. So there's kind of a waterfall effect when there are multiple moves. But staff would be involved in managing the movement of furnishings from one chambers to another, and identifying problems with furnishings or issues related to the move.
But who was responsible for making sure this judge had what she needed when she started work? As far as accoutrements?
Well, I think ultimately, I mean, I feel responsible, but normally there would be, just from the movement of furnishings, there's going to be furnishings available. So I was unaware that there would be no primary desk and no counsel table, but once we identified that issue, we would move to procure those.
And how were the furnishings procured for Judge Williams so she could start day one with everything that she needed?
I don't recall the specifics, but I know that we identified the areas of need, which was a counsel table and a desk, and court administration did order those on behalf of Judge Williams.
Did she have those available on her first day of work?
No,
Okay.
no.
Well, when did she have those available?
I don't recall, but it would have been at minimum weeks. It could have been 4 to 6 weeks. I don't recall
What did
Duration.
Judge, oh, I'm sorry, I didn't mean to cut you off.
I don't recall the exact duration. It would not have been immediately.
So what did she do during the interim, if you know?
I don't know.
Do you think that not having what she needed on day one was embarrassing to Judge Williams?
I do sustain that objection. I don't know that he can say what she thought.
Well, Mr. Summerlin testified that he was with Judge Williams when she saw the office. Will you allow the question?
Well, I think he can say what his personal observations of her demeanor and that kind of thing are, sure. I just don't think he can get inside her head.
Yes. Will you describe Judge Williams' personal demeanor upon seeing the space that was set aside for her?
Perhaps surprised that there was not, those pieces were not there, or there was not furnishings in place. Perhaps disappointment.
Thank you. And Mr. Summerlin, I'm not trying to beat up on you with this. We're just trying to give the panel a sense of what day one looked like for Judge Williams. So let me move on here. When Judge Williams took the bench in January 2021, did she have a particular assignment within the court?
Yes, when she took the bench, she was assigned to the family division.
Why?
We have a policy, we have 4 judges that are assigned to our family division. There were 2 vacancies at the time, and those vacancies can be filled by volunteers, and if there are no volunteers, they can be filled by seniority. Either the most senior or the least senior judge who's not served on that division. And so one of the positions was filled by volunteer, and the other was filled by Judge Williams as the least senior judge.
Okay, let me back up a bit. There were two of the seats in family were vacant, right?
Correct.
Do you know who occupied those seats before the vacancy?
Judge Reeder and Judge Edwards.
So was it the custom that the new judge gets put on the family court?
The timing, there's not always an opening on the family court when a new judge starts, but in this instance there was. We did have a volunteer, and we were at a point, we rotate between the most senior and the least senior. We were at the point in the rotation of least senior, and Judge Williams was the least senior judge, so she was assigned to that division.
Was she required to go to family court? What if she'd said, I got elected to be a judge for everything, I'm gonna take a regular calendar, what would you have done?
I don't know what I would have done. I believe that would have been up to the chief judge to determine the best course of action. I've not seen that scenario.
Mr. Summerlin, you mentioned that Judge Williams was the least senior judge at the time who came on. Is that right?
Correct.
Okay. Now, wasn't someone else elected at the same time Judge Williams was elected?
Yes, Judge Melanie Leffridge was elected.
So as between Judge Williams and Judge Leffridge, why was Judge Williams the least senior if they came on at the same time?
Several months in the fall of 2020, we basically, under the supervision of the judges at a bench meeting, drew names out of a hat, and it was done by court administration. My staff did that. We drew 2 names out of a bowl and to determine seniority.
Is that the practice that had been done in the past?
A random selection process has been implemented in the past. I can't remember if it was done in that manner or not, but there has been a random similar process in the past.
Random meaning straws and not bowls, something
Right.
similar, random.
Yes.
Was the other judge elected at the same time, Judge Williams?
Yes, I believe they were elected during the same election
So
cycle.
they started at the exact same time?
Yes. Now, I don't recall if one judge was sworn in before the other and those types of details, but they did start generally.
Well,
at the same
doesn't that detail determine in most circuits who has seniority? Let's say Judge Burleson gets sworn in 3 minutes before Judge Lopez. Judge Burleson forever has seniority over Judge Lopez, doesn't she?
Yes, that makes sense. And I can't recall, I think.
Well, I don't think it makes sense. I'm just telling you the
Okay,
way it is.
understood.
Yeah.
Picking up on Commissioner Hyde's point, does seniority matter?
Yes.
Why? How?
Well, several things, including this policy I just described about the family division, where if there are no volunteers, it's either the most senior or least senior judge. There are other areas, for example, when a chambers is vacated, a more senior judge can elect to move to that chamber space in that courtroom. Or a parking spot in the park, if a judge retires and they have a more desirable parking spot, a more senior judge can elect to take that parking spot. So there are different benefits to having seniority.
Down to parking spots, huh?
Yes.
Okay. You mentioned in your testimony, Mr. Summerlin, that Judge Leffridge and Judge Williams were elected at the same time.
Yes.
Do you know if Judge Leffridge was elected in a runoff, or was it at the same time?
I don't recall, but I believe it was during the same election.
Okay. Now, if Judge Leffridge was elected after Judge Williams in a runoff, would that have made Judge Williams the more senior judge?
Not that I'm aware.
Okay. Does that part not matter for the process of determining seniority?
It was not something that we looked at, that I recall.
Okay. Now, you also mentioned about the 2 seats that were vacated. They were vacated by former Judge Reeder and Judge Edwards. So,
Yes.
starting with Judge Edwards, why did she vacate the seat?
She had served either 1 or 2 terms already. She was completing a term on the family division and had opted to go back into, either had opted or had served the maximum number of terms to go. So she needed to go back into a mixed docket division.
And how long is the term?
2 years.
And could she have served longer than the 2-year term?
There's an option. I think that each judge can serve up to 2 terms. The second term would be at the judge's election.
Is the serving in the family division considered desirable among judges on the court?
I think it just depends on the judges. It is certainly unique and a challenging role and a challenging division to work in. And I think it just depends on the background of the judge who's making that determination.
Okay. I'll come back to that point. Judge Reeder, was her seat vacated because she lost the election to Judge Williams?
Yes.
Okay. So we've got 2 vacant seats in the family division at the time that Judge Williams and Judge Leffridge joined the court. Judge Williams goes to family division, right?
Yes.
And Judge Leffridge goes where?
She was in a mixed docket caseload, a standard mixed docket caseload.
Are there any other special divisions in the court other than family?
We have a business case division as well.
Is that an option for new judges?
No.
Who fills the second seat that was vacated on the family division at the time that,
Judge Farmer,
why?
he elected to go, he volunteered for the position.
Do you recall, Mr. Summerlin, any other time that a brand-new judge was assigned to the family division?
I don't recall.
You mentioned in your testimony that the family division, serving in the family division, is a unique and challenging role. What did you mean by that?
There's a large volume of domestic cases that come through our court, and a large portion of those domestic cases are pro se litigants. So it can be a challenge.
Why is it a challenge dealing with pro se litigants?
Typically, I think that there's probably more procedural issues, there's more administrative issues as a case moves through the system that require more attention by the judge.
And how about the caseload? Are there any differences in the caseload in the family division versus the mixed court?
Well, it's unique in the sense that it's all domestic cases, and I think domestic cases make up probably a majority of all civil cases that are assigned to our court.
Okay. So, let's make that plain. Of the civil cases assigned to the court, you mean non-criminal?
Correct.
Okay. And so civil meaning other types of cases other than family? What other kinds of cases?
Tort disputes, other disputes, business disputes, any kind of civil lawsuit.
Okay. Of all of the civil, including all the types that you just mentioned, family makes up the majority of the civil?
There are more domestic cases than there are other within that civil category.
Okay. Would you tell the panel about the work of the family division? What does it do?
Well, our 4 family division judges handle custody, they handle divorce, custody, legitimation, all types of cases. And then we also have a operation that handles a lot of domestic violence cases and name changes and vital records and those types of things.
And are the judges in the family division responsible for all of those things, or a subset of those things that you mentioned?
Well, each family division judge has a caseload that's assigned to them through a random process. So those matters that are not filed in the family division operation, we call it FAM 5 internally, but those things that do not go there, like domestic violence filings, those types of things, everything else goes to those family division judges, all other domestic matters.
Is there a chief of the family division?
Yes.
Can you tell the hearing panel about how that process works?
We have a policy in place for the chief of the family division. The term is 18 months. It typically goes to the most senior judge within the division who has not yet served as the chief. So that's how it kind of works. And there's an 18-month term, and once that term is up, it's the next most senior judge, if they're willing to serve in that position.
And at some point, was Judge Williams the chief of the family division?
Yes.
Do you know when?
2023, all of 2023 and half of 2024, so about 18 months during that period.
At that point, would she have been the most senior judge within the family division?
It is possible because, as I mentioned, Judge Farmer and Judge Williams were the 2 newer judges coming in when Judge Williams started. At that time, there were 2 more senior judges who had rotated off of the family division. So Judge Williams could have been the next most senior at a given point. She could have been the next most senior judge within the division.
But Judge Farmer, hadn't he been a judge longer than Judge Williams had been?
He had been a judge, and he did serve. He did serve as chief judge, and so Judge Williams would have followed Judge Farmer at some point.
Okay. Would the chief role be something that Judge Williams had volunteered for, or did it happen by order of seniority?
It could, let's see, it may have happened by order of seniority based on who was in the division at the time, the family division, not seniority as a superior court judge, but seniority within the division. So it may have been that she was the most senior who had not served within the division.
Okay. And what is the job of the chief judge in the family division?
They kind of address, I guess, systematic issues. They work with the other 3 judges. They meet, whether monthly or quarterly, to discuss kind of I'll call it system issues, systems that are kind of impacting everybody. The chief judge would support the FAM 5 division, which is court administration's division of the family division, in terms of domestic violence and all those things that kind of come through that channel. So the chief judge would support the director of the family division in that role.
Do you know if Judge Williams served the full 18-month term as chief judge?
She did.
Do you have any opinion about how Judge Williams did in her role as chief?
I don't have an opinion, but it was normal. Everything was normal. There were no issues that I'm aware of. I know that they met frequently, and yeah, that's about it.
Did you have occasion to observe Judge Williams in her performing her chief judge duties?
I did, perhaps within family division meetings, or talking to her about some issues, or talking with her and the family division director about some issues that could be specific to the family division.
What is your impression of Judge Williams as a professional, as a judge?
She's always been very professional with me, and always very courteous and professional, and I would say understanding.
How about in her interactions with others that you've observed?
It would be the same. I've not observed anything any different than that.
Are you aware of whether Judge Williams was asked at any point during her service as chief to step down after the allegations, in this case, have become public?
I'm not aware of that.
How about even outside of her role as chief? Are you aware of any time that Judge Williams are you aware of whether Judge Williams was asked to step down from the family division after the allegations against her had become public?
No, I'm not aware.
Would you have been aware if it had happened?
I believe so.
Why?
As the court administrator, we would be involved in terms of if somebody's going to be change assignments. We'd be involved in terms of determining how that process is going to work, what caseload they're going to inherit, how the process to fill that position is going to occur, all of those types of things.
If a judge in the family division is not performing well in the role, is your office involved in that at all?
No. I mean, occasionally we might get complaints about a judge, and I'm not speaking of Judge Williams or any specific judge in the family division, but we may get a complaint, which typically we refer them to the JQC, or we provide information so that they can make a formal complaint.
Are you aware of any complaint your office received about Judge Williams?
I don't recall any.
Let me shift gears and ask you about senior judges. There have been some discussion in this case about senior judge assignments and the work of senior judges. How are senior judges used in the family division?
I think they're used in similar ways as they are in other divisions. Each one of our judges, whether they be in family division or otherwise, gets an allocation of senior judge days. So they get a limited number. It could be 7 days, it could be 10 days of senior judge days, and it's up to that judge to determine, how they will use those. Some judges might use them when they're at a conference or absent or out sick or something like that. And then others may use it because a trial runs long and they have something else scheduled and they need to bring in a senior judge to assist in handling other matters.
In your experience, are whole cases ever assigned to a senior judge for disposition from start to finish?
I think it would be unusual. I'm not aware of any off the top of my head. The case remains, in our system, the case remains assigned to the original judge. Even if a senior judge assists, it remains assigned to that original judge.
Are you aware of any uses of senior judges outside of what you described if a judge is on vacation or conference or something for a limited period?
Only in the event of a recusal, where we have to either have an outside judge come in or a senior judge to assist, only in an incident like that.
Who pays for the senior judge's work?
It's a combination. We receive funding through the state of Georgia, Council of Superior Court Judges. We receive a allocation, so we use those funds. And we also have a small local budget as well that we also can use.
Are you aware if a litigant asks for her case to be heard by a senior judge, is that something that could be facilitated by the family division?
I'm not aware of a process where somebody can request a senior judge specifically to handle their matter. I'm not aware of it.
If someone said that their family or domestic case could have been transferred to a senior judge, would they have been mistaken?
I would think so, because it can't be transferred to a senior judge, again, unless there's unusual circumstances that would require that.
Okay. All right, Mr. Summerlin, I want to ask you about a particular report. Caseload summary reports, are you familiar with those?
Yes.
Okay. Tell the hearing panel what those are.
Monthly, each month, court administration prepares what we call a caseload binder report, and that is sent out to the judges monthly. And it's basically a high-level breakdown of caseloads, starting new case assignments and ending dispositions and ending caseload balances. And it applies for all of our various judges, and I think partly maybe our business court and our family division that handles the domestic violence matters.
What is the purpose of the caseload summary?
It's just it's a high-level snapshot that goes out to our bench, and so our judges will review that information. I think each judge may have their own process in terms of how they might analyze that, or what other data they might retrieve out of the system to compare or to manage that caseload.
I want to show you some compiled caseload summary reports.
Does each judge get it just for themselves, or do they get it for the other 19 judges?
It's collective, and it goes out, so each judge sees, everybody sees everybody's numbers.
Yes, ma'am.
Do you have copies of this? Do you have extras?
I am sure we do, if you can tell me what tab it is. I didn't see it on the joint exhibit
We don't have it.
list.
We don't have it.
I have some extras.
Yeah, my binder is just the joint and the joint table, I think.
Would you like a copy of
We
it?
would,
Okay.
yeah, if you've got extras, that'd be great, thank you. And what are you marking that as, Ms. McFadden?
R3.
Thank you.
R3? Now, I have from our last hearing, something marked as R3 as a transcript of a temporary hearing.
We have in the official exhibit R1, which is the transcript of Judge Williams' interview in front of the JPC. R2 is respondent's motion for refusal.
I have R1 as transcript December 14th, 2021 hearing. R2 affidavit of Brandy Alexander and the motion to recuse. And R3 I have was a transcript of some sort of temporary hearing that was never tendered or admitted, but it was identified. So are we, so,
We can just mark this one as our R4, if that's okay.
that's fine.
Thank you.
Any objection to R4, Ms. Beal?
No, Your
All
Honor.
right, R4 is admitted then.
Mr. Summerlin, can you describe what you have before you?
This is a page from the binder. The binder is a collective of documents and reports. This is a page from that monthly caseload binder that we send out each month.
Do you determine, as court administrator, what the headings will be? For instance, somebody decided what to put in each column, right?
Yes.
Was that you or your staff?
Yes. No, I mean, it could have been a conversation with judges in the past, but we probably used this format for the last 4 to 5 years. But yes, ultimately it's a decision, and it's something that we determine.
And do you have this also for criminal matters too?
Yes.
And how did you decide to put in the very far right of the column, pending more than 18 months, as opposed to some other number?
I did not decide that we would include that particular column, but it was something that was determined, I would say, years ago.
Okay.
And we just know that I think 18 months is kind of generally accepted kind of a time frame where, you know, if something goes beyond that.
Even though the law says 90 days.
Yeah.
Thank you.
Well, the pending 18 months, though, that doesn't necessarily mean an order is outstanding for 18 months, right? It just means the case has been open and pending
From
for
the
18
file date,
months?
from the file date,
Gotcha.
Okay, so not an order.
correct.
Gotcha.
Mr. Summerlin, you described the first page of that document. You've got many pages. What are the other pages?
Bear with me, I'm getting to the age where I need readers.
I have some readers if you'd like them.
I'll try to manage.
Okay.
So, and your question is?
Describe the set of documents you have.
Okay, so we're looking, the first page is January 2021, and it appears to go through approximately, or it goes through each month up until December 2024.
Okay. And you mentioned that that's just an excerpt of the full report that you provide to the judges.
Yes,
And have you reviewed the compiled exhibit of the monthly reports that
yes.
you've been handed?
Yes, I have.
Did you identify any discrepancies in the reports?
I did not identify discrepancies within the individual reports, but I do believe we're missing a month. I think it's missing January. Maybe 2023?
Okay. We have supplemented that exhibit to include January 2023. January 2024, is that month missing?
January 2024 is missing. We had a cyber event in Fulton County during the first part of 2024 that started at the end of January and prevented us from preparing the reports that were necessary to generate this binder report
Okay.
by mid-February.
So Commissioner Hyde started to ask you about these columns. Let's walk through them so that the panel can understand what we're looking at. And I just put up on the screen for everyone just the first page of the report from January 2021, but each monthly report is in the same format. Is that right, Mr. Summerlin?
Yes.
Okay. And so since this is a report from January 2021, would this be based on stats from that month or the prior month?
So this is the January report. So this would have come out in February, and it would have been for the month of January.
Okay. So the first column we see with names and family 1, 2, 3, 4 in parentheses. Can you describe that column? What is that?
This is the judge or division.
Okay. So Judge Farmer, Judge Swall, Judge Williams, Judge Glanville, is that right?
That's correct.
Okay. I don't think I asked you how was it decided for the 2 vacancies that there were in January, as of January 2021, how was it decided which judge would go to which family? Family 1, family 2, family 3, family 4?
There were 2 openings in FAM 1 and FAM 3. There were 2 openings. Judge Farmer volunteering probably in December or even November prior to January, and being the most senior judge was able to select which caseload he would inherit.
Okay. And which caseload did he inherit? Which vacancy was family 1?
Judge Reeder.
And so does that mean Judge Williams inherited family 3 that was vacated by Judge Edwards?
Yes.
Okay. But Judge Williams didn't have a choice in it because Judge Farmer had already chosen. Is that right?
Yes. Yes.
Do you know why Judge Farmer would have chosen family 1?
I don't know. I didn't discuss it with him.
All right, let's talk about the next column, beginning pending caseload. What do those numbers represent?
That would have been the remaining caseload as of the end of January 2021.
So does that mean, in Judge Williams' case, well, we see 501, 545, is that 636, 590 in that column? Are those the cases, the number of cases that the judge would have had at the beginning of the month?
Yeah, I'm going to correct.
Okay.
I may have misspoke. That is the starting point. That is a starting caseload at the beginning of January, not what was remaining at the end.
Okay, starting caseload. So of these numbers, Judge Williams or Family 3 has the most. Why is that at 636?
I don't know why it's the most, but it was a higher caseload, certainly.
Okay. The next column, new cases. What is that? What do those numbers represent there?
Those are cases that would have been assigned to each division in the case management system.
So new cases coming into Family Division?
Yes.
And how does that process work? How does a new case get assigned to each judge?
We call it through a wheel, but it's through software. It's the case management system randomly assigns each division cases.
And in some months in the report, judges are assigned more, some judges are assigned fewer. Do you know why that would be the case? If we would have a judge who got 110 cases in the new case column and a judge that got 80 cases, why would that be such a difference?
I don't know why it would be such a difference, but it's my understanding that the case management system takes into account various things, like if a division receives transfers in that come in that are not system assigned, but it accounts for those in some way. So it could be a combination of things that could make that result.
Okay. So the next few columns we see reopens, transfers in, transfers out. Can you talk about those?
The reopens would obviously be a case that's reopened. It could be because a case was inadvertently closed in the clerk's office. It could be, I guess, different things that could cause a case to be closed and need to be reopened. Transfers in could be a case where one of the family division judges has a related case. There's more than one case that are related, and so a case is transferred from one division to the next because there's a related case. And same thing with transfers out. It could be for the same types of reasons.
Okay. Cases disposed. Tell us about that column.
This would be the cases that are resolved during that month. So that would have been the number of cases resolved in the month of January.
So in Judge Williams' case, is it a fair reading that for the month of January 2021, she resolved 109 cases?
Yes.
Okay. And she got in 97 cases?
Yes.
New cases, okay. Without regard to the transfers in and transfers out?
Correct.
All right. And the next column, ending pending caseload. What is that?
It should be the result of looking at the starting point, the beginning caseload for the month, all the transactions in between, which would be new assignments, closures, and all the other things, and that should result in the ending pending caseload.
And if I'm reading this right, the ending pending caseload as of January 2021, we should see in February, that is the beginning pending caseload?
Yes.
Okay. And then the last column, pending greater than 18 months. Commissioner Hyde asked you about that. What does that column represent?
Those are simply cases that were filed more than 18 months ago, 18 or more months ago.
Does the judge not get information on if an order has been waited on more than 90 days?
Not through this reporting or not through any report provided by court administration.
So who provides it?
I'm not sure that anybody provides it outside of the judge's chamber. My belief would be that they would use the case management system to either generate their own reports or to review the cases within the case management system.
And could you have included that on this? Is there an ability to have included it on this?
The answer is I don't know. Not that I'm aware, but I don't know. I could be wrong.
It just seems to me that's a very important number. If we're going to charge judges with failure to rule, they get this, the failure to rule carries with it a pretty harsh sanction. None of these others do, right?
Right.
Is there any part of the system that the court uses that gives a ping or warning when there is something, motion that has been pending for greater than 90 days, to your knowledge?
The system, my understanding, the system has the capability, but I'm not sure if it's something that's utilized by our court or if it's used by individual judges, or I'm not aware of that particular feature within the system.
Okay. Let me ask you a related question. There's been some testimony before the hearing panel about judges not getting, if a new motion is filed, the system doesn't automatically say, hey, judge, we have this new motion. Is that correct?
Not that I'm aware of.
So the judge does not automatically get notice of the new motion?
I really don't know if there is a notification for that or not. I really don't know.
So, back to the chart, the pending greater than 18 months, that is from the time that a new matter is opened. Is that right?
Right. It's when the case is filed or opened.
So is it fair to say that when Judge Williams joined in January, she had a beginning pending caseload of 636 cases, and she had 62 cases? I have readers on and I still can't read this. She had 62 cases, if that's a 6, in the pending greater than 18 months
Yes.
column?
Yes.
Okay. And family 4 had 82?
Yes.
Okay. Is there some kind of rule of thumb or standard the court uses to determine how many cases a judge should dispose of in a given month?
I think it's just widely accepted that you need to at least clear 100%, which is as much as you're getting in for each month. You need to clear at least that many, or more if possible.
Okay. So if a judge got in 97 new cases, it would be good if the judge disposed of at least 97 cases.
Yes.
Okay. And then with the pending greater than 18 months, I imagine that the magic number would be 0, but is there any standard or benchmark for that column?
Not that I'm aware of.
There is so we see this line up for the judges that were in place in the family division as of January 2021. I want to ask you about Judge Newkirk. And the report from December 2023. So at some point, and we're not going to walk through all the pages of the report, but at some point the makeup of the family division changes, just with the people's terms expiring, et cetera. Is that right?
Yes.
Okay. And so at this point, at least in December 2023, we've got Judge Farmer, Judge Ellerby, Judge Williams, and Judge Newkirk, right?
Yes.
Okay. Now, at some point, though, prior to this, Judge Newkirk had retired. Is that right?
He did.
All right, so tell the panel why Judge Newkirk still shows up here as having a caseload, new cases in, cases disposed of.
He really shouldn't show up here in December of 2023 because he left in, I believe, May of 2023, or at the end of May 2023. And his name should have been removed from the report once he had left the bench.
Were new cases still getting assigned to Family 4, even though there was no, I guess, active judge after Judge Newkirk left?
Yes. Cases continued to be assigned in the same manner.
How were those cases being handled with no judge?
When Judge Newkirk left, his judicial officer and his staff remained. And so they continued to handle cases that were already on the docket, and those incoming cases, they continued to process those cases.
What is a judicial officer?
It's an attorney who meets the qualifications to serve as, meets all the qualifications that a judge would be required of a judge.
So they're otherwise qualified.
Yes, and they're appointed by our court and by our chief judge to serve as a judicial officer.
And what's the authority for that, do you know?
I don't recall, I mean, I know that it's unique to the Superior Court of Fulton County. It's in our family division rules, so there is some unique aspects of our family division compared to other courts within the state.
So you folks just pass a rule to create other judicial officers?
There was a rule passed, and I
Okay.
believe it was okayed by the Supreme Court and others. But it's many years ago, many years before my time.
This panel has heard testimony about a litigant's ability to request an elected or appointed judge and not a judicial officer to hear their cases. When Judge Newkirk had retired and was no longer there, and you had people saying, I want a judge, an elected or appointed judge, how were those matters handled?
That was an issue that came up after Judge Newkirk left. I don't recall if it was a month or a couple of months, but I believe there may have been complaints, or the staff, Judge Newkirk's former staff, may have come forward and said, hey, we're getting these requests. People are requesting to have an elected judge handle their case. And basically, I think they were probably incorrectly, telling folks, well, hey, you're going to have to wait. So at some point, it bubbled up to our chief judge of family division, Judge Williams, and our chief judge, Judge Glanville, that there was an issue, and it was discussed. And I believe that both Judge Glanville and Judge Williams basically gave the direction to the staff and to the judicial officer, if you have this scenario, let us know and we will assist.
Do you know if Judge Williams took on some of the cases that were assigned to Judge Newkirk's division?
I don't know of a specific case, but I know that she offered to support, and I know that she was providing guidance.
Do you know if you mentioned Judge Glanville, was Judge Glanville, at this time, how was Judge Glanville involved in family?
Just as the chief judge, and I don't recall if Judge Williams would have brought it to Judge Glanville's attention or how it was brought to his attention, but I know that he was aware of the issue, and it was discussed with the staff, with Judge Newkirk's former staff.
Judge Glanville was the chief of the entire court, is that
Yes.
right? Okay, not chief of family.
Correct.
Got it. Do you know if Judge Ellerby or Judge Farmer, if they were involved in handling cases that were assigned to Judge Newkirk at this time?
I'm not aware.
Mr. Summerlin, before I move on from the reports, let me ask you about the December 2024 report. Do you know, Mr. Summerlin, how long Judge Williams served in the family division?
She served 2 full terms, which would be each term being 2 years, so she served 4 years.
Okay. Was December 2024 the last month of her term then?
Yes.
So during the last month of Judge Williams' term, Can you describe to us what her caseload looked like based on the numbers that are included in the report?
Can you ask again? Sorry.
Yeah. Based on this December 2024 report, can you describe what her caseload looked like, her beginning, pending caseload, new cases open, closed, and where she ended up as of the end of December 2024?
She started the month of December 2024 with 548 cases. She received 96 new cases, 1 reopened, 2 transfers in, 5 transfers out. She disposed of 112 cases. I think there's an additional column here that maybe wasn't on the first report, but it's post-judgment. It was kind of a breakout of post-judgment matters. So she had 66 post-judgment matters, I guess, assigned. And then the ending caseload she had 75 post-judgment matters assigned, and the ending caseload was 536 cases.
Okay, and then pending greater than 18 months?
Can you slide that document over? Is there a way? There's an app here that's blocking. Yeah, there you go. 18 cases pending, 18 that were filed 18 months or greater before.
And so is it fair to say that Judge Williams started out her tenure in family with 636 cases, but ended with 536 cases?
Yes,
And started with a pending greater than caseload number of 62, but ended with 18?
that is correct.
And it looks to me that of the 4 family judges she has in the beginning pending caseload column, she has the second lowest case count.
Yes.
Is that right?
That's a
Okay.
fair assessment, yes.
You mentioned the new column that was added, post-judgment matters. What is that?
These are matters that may come up. I can't recall the specific types of situations, but these are matters where something happens after the case is closed that has to be addressed by the court. And so that was a way, and I can't recall why we decided to capture that data, but we added that data point to the report.
Okay. Can the judges say, hey, Mr. Summerlin, I want you to capture certain data points going forward, and it happens, or is there another way that happens?
Well, it would require more than a judge asking. It would require bench discussion and some input by the bench.
Okay. I wanted to back up and ask you about your testimony about the senior judges, just a couple of clarification points. You mentioned senior judges and recusal. Is there a difference between general individual recusal and bench right recusal with respect to senior judges, the use of senior judges?
Is there a difference?
Yes.
Typically, if they're in our system, typically if a judge recuses and it doesn't meet the criteria of being a bench-wide recusal, it would be randomly assigned again. It would be randomly assigned to a judge on the bench.
And so how would a senior judge play into that, if at all?
Through that, what I just described, they typically would not come into that scenario unless the judge assigned the case needed a senior judge to assist for some reason.
When judges or elected officials have matters in the family division, are those matters handled by a senior judge or some other process?
Can you repeat? Sorry.
If there was a judge or an elected official that had a matter in front of, in the family division in particular, are those matters treated in any different kind of way with respect to senior judges?
Not that I'm aware.
Are they transferred out of the county?
I guess that could happen in certain circumstances if our full bench or this person was a judge on the bench that was all of our judges obviously have a relationship with. I guess there could be a scenario where that would happen.
Okay. Have you spoken with anyone from the JQC about this matter?
Yes,
Okay. Who was that?
the director.
For what purpose?
just to discuss, I guess, evidence that's been prepared in this case.
How long ago?
Several weeks.
Do you recall talking to the director before the formal charges against Judge Williams were brought?
I don't recall, no.
Were you ever asked to produce a copy of these caseload summary reports prior to this hearing?
No.
Prior to this hearing, did anyone from the JQC ask you about how Judge Williams did in closing out cases as compared to other judges?
Can you repeat the question?
Sure. Prior to this hearing, did anyone ask you how Judge Williams performed in closing out cases as compared to other judges?
I don't recall specifically, no.
Generally? Would you have talked to anyone from the JQC, the director's office, if they had called you sooner?
Of course.
Just a couple more questions for you. Mr. Summerlin, you noted that you had interacted with Judge Williams. What is your impression, or do you have an impression of Judge Williams' work ethic?
In my capacity, I don't interact with Judge Williams in the courtroom or while she's doing her work as a judge, other than maybe more so in administrative matters where she needs something from me or if I need something from her. But I will say that she's always been very courteous and professional, and there are many days I'm one of the last folks to leave the courthouse, and Judge Williams is many times also one of the last judges remaining in the courthouse.
Around what time is that normally?
It could be after 7 o'clock and all the way up to about 9 o'clock at night.
I think that's all I have for you right now. Thank you.
Questions of this witness on behalf of the commission? Investigative panel.
The director. The director.
Good morning, Mr. Summerlin.
Good
I know
morning.
we've spoken before, but to be clear, I'm the director of the JQC, but prosecuting this case on behalf of the investigative panel of the JQC. And I appreciate you being here today. I've just got a few questions for you.
All right. Thank you.
You indicated that you are currently the district court administrator as well as the court administrator for Superior Court in Fulton County, correct?
Mm-hmm.
Who selects you or hired you for each of those positions?
In our court, it's the position is really one and the same. We're unique in the sense that the Atlanta Judicial Circuit is the 5th Judicial Administrative District. We're the only district in the state of Georgia with just one circuit. So it's kind of comes hand in hand.
And so who selected or hired you for the position?
Ultimately, the bench, the chief judge makes the offer, if you will, the hiring, I guess, decision, but with the input from the full Superior Court bench.
Okay. And you indicated that you have 3 deputy court administrators. Who makes hiring selections for those positions?
I make those hiring decisions.
Okay. Do you have to run those by the Superior Court judges or the Chief Superior Court Judge?
No, but I will. I will do that. I will speak to the chief judge about any position at that level that I would fill.
Okay. When Judge Williams took the bench in January of 2021, we were still experiencing or kind of in the thick of the COVID pandemic, correct?
Yes.
Okay. I understand that the judges in Fulton County, specifically Superior Court, I understand many of them were conducting hearings and their proceedings remotely or virtually. Is that correct?
Yes.
Do you know whether when the Superior Court judges were doing that, they were actually physically in the courthouse or they were elsewhere?
I don't, but I mean, I'm aware that there's been a combination of ways that that was done, whether it be from the bench or whether it be from their chambers or otherwise.
Okay. But certainly court administration ensured that the Superior Court judges during that time had the ability to preside over hearings and conduct the business of the court from wherever they may be, correct?
Yes,
So they didn't need a conference table or a fully furnished office to perform the duties of their office, correct?
that's a fair assessment, correct.
Okay. Were you aware that the chambers that Judge Williams inherited actually had belonged to Judge Krause?
Am I aware? Yes.
Yes, I'm sorry.
Yes.
Sir, you were aware.
Yes,
Okay, so the chambers that you described Judge Williams walking into and there not being the conference table and you described it as abnormal, that chambers belonged previously to Judge Krause,
that is correct.
not Judge Reeder.
That is correct.
Okay. And what happened was when Judge Reeder left and vacated her chambers, Judge Krause moved into Judge Reeder's former chambers, correct?
That is correct.
Okay. And you indicated on direct that based on seniority, the judges will sometimes move their chambers or, it even impacts parking spaces, correct?
That is correct.
Okay. There's been an allegation made in this case that Judge Reeder gave away all the furniture in the chambers that Judge Williams inherited. Do you have any knowledge of Judge Reeder giving away all that furniture?
I don't have any direct knowledge of that.
Okay. You were asked on direct whether you were aware of any brand-new judges to the Fulton Superior Court bench starting off in the family division. And did you indicate you were unsure about whether?
I didn't recall.
Okay.
I'd served as a court administrator since 2019 going into 2020. So during that time and maybe just before that, I just don't recall.
Okay. Do you know whether that was the case with Judge Reeder, that right after she became a judge, she started in the family division?
I can't recall. I'm sorry.
It's okay. Are you aware that Judge Reeder was appointed to the bench in 2018? Does that sound correct?
Yes.
Okay. And then she lost her election to Judge Williams in 2020, correct?
Yes.
Okay. During Judge Reeder's tenure on the Fulton County Superior Court bench, she was assigned to the family division the entire time, correct?
Yes.
Okay. You indicated that the terms on the family division are 2-year terms at the expiration of the first term. So at the expiration of a judge's 2 years, their first term on the bench, the decision is left up to them whether they want to remain on the Fulton County bench, correct? Or on the family law bench?
Yes.
Okay. And Judge Williams decided to remain on the family law bench for an additional 2 years.
Yes.
Understanding that the judges in the family division have a good number of cases and they're complex cases in many instances, each of those judges in the Family Law Division get a JO, correct?
Yes,
Okay. And that is different from any of the other judges on the Fulton County Superior Court bench.
yes.
Right.
It is unique.
Those other judges don't have essentially a second judge helping them out with their caseload, right?
That's correct.
Okay. The JOs you indicated have the qualifications, if you will. I think you stated to, be a judge. They're practicing lawyers and they have to have a certain amount of experience, and then family law experience is preferred,
Yes.
right? Okay. Are you able to tell us, well, actually, I'm sorry. Let me back up. I'm showing you this, the case report that we were talking through earlier. These numbers on this report, and so let's just talk about this beginning pending caseload number. That number captures both the cases that are both the cases assigned to the JO and being handled by the JO, as well as the cases that are being handled by the elected Superior Court judge, correct?
Yes, they're assigned to that division. And in that case, for example, FAM 3 has 636 cases assigned.
Okay. And then, so the same for the cases disposed category. So Judge Williams disposed 109 cases in January of 2021. That number captures not only the cases resolved by Judge Williams, but also the cases that would have been resolved by her JO, correct?
Yes, the cases that could have been resolved along the process.
Okay.
Why isn't it broken down where the public can know what the JO is doing and what the elected or appointed Superior Court judge is doing?
I don't know why it's broken down, but they certainly work as a team in tandem. But I don't know why it's not reported.
The JOs write their own orders, correct?
Yes,
They don't have staff attorneys.
no.
Are you able to say what percentage, on average, of a family division elected Superior Court judge's caseload a JO handles? Is it 40%, 50%?
I don't know, but I would say they touch each case at some point in the process.
Okay. All right, you indicated that during the time that Judge Williams was chief of the family division, you were not aware of any issues with the operation of the family division, correct?
Correct.
Were you ever made aware of the multiple cases assigned to Judge Williams where the lawyers had been waiting on orders for months and sometimes years from Judge Williams' office?
Was I notified? Was I aware? I don't recall being aware, made aware.
Okay. Just to clarify, I know we've talked, you testified at some length about the recusal process, and I don't want to beat you over the head with that, but in a scenario where the entire family bench were to recuse from a specific case, that would be a situation where a senior judge would be brought in to handle that case through conclusion, correct? Or that could happen, correct?
That could be a scenario.
Okay.
So you're saying nobody ever complained to you of Judge Williams being late on orders?
I don't recall receiving any complaints directly to me.
But you get complaints on other judges on other things, I guess, just in the courthouse working there?
Occasionally, we do it. It's not something that happens from, week to week or month to month necessarily, but we typically, if we do get a complaint, we will refer them to the JQC, give them the information in terms of the process.
And when you do get a complaint, are those complaints from lawyers that have cases pending in front of the judge?
It could be a combination of pro se litigants or attorneys. I would say typically more so that folks that would show up in my office might be pro se litigants.
Okay. All right, I think that's all I have. Thank you.
Anything further of this witness, Ms. McFadden?
Mr. Summerlin, Director Veal asked you about when Judge Williams started. It was during the COVID era, and lots of hearings were conducted via Zoom, right? Do you know whether some judges still came into the office, came into the courthouse to work?
Yes.
Okay. Do you know whether Judge Williams came into the courthouse to work?
I don't recall specifically, but Judge Williams was at the courthouse quite often, so I would believe that she would have during that same time frame.
And some judges conducted their Zoom hearings from their courthouse, from their courtrooms. Is that right?
Yes.
Okay. Not to delve too deeply into the furniture issue, but one question for you. At some point, both Judge Krause and former Judge Reeder had full sets of furniture in their offices, right?
I believe that they did.
And something happened to at least one of those sets of furniture.
Yes. There were other moves that were occurring at the same time. There was a lot of moving pieces, so that's why I'm not as clear on that.
All right. I want you to clarify your testimony in one respect with respect to former Judge Reeder. Do you know if she moved to family in March of 2020 from the broader division of the court, or the broader docket?
I don't recall. I know that she may have served on the accountability courts, but I can't recall if that was while she was simultaneously a family division judge or not. I'm not able to recall back that far right
so
now.
you don't recall whether Judge Reeder served in family for the full entirety of her service on the court?
I can't recall when she started, but I know that she did end her term, and she was with the court about 2 years, and she did finish in the family division.
Okay. You can't say whether she started there, but you know she finished there.
I can't recall specifically if she
Okay.
started there.
All right. The JOs, there was some testimony about the JOs. The JOs are under the supervision of the judges. Is that right?
Yes.
Okay. The judges provide them instruction?
Yes.
Do the judges hire their JOs?
Yes.
Okay. Do the judges terminate their JOs?
Yes.
Okay. That's all I have. Thank you.
Anything else, Ms. Veal?
No, Your Honor.
All right. May we excuse Mr. Summerlin?
Yes.
Any objection to that?
No, Your Honor.
You guys got anything else? Thank you, Mr.
Thank
Summerlin.
you.
Appreciate it. Next witness?
Thank you. Good morning.
Good morning.
Judge Williams calls Tangi Bush. I was about to give you a judge title. I'm sorry. Want to swear you.
Okay.
Do you swear or affirm the testimony that you are about to give is full and true to the best of your knowledge?
Yes.
Would you please state your name for the record?
Sure, it's Tangi Bush, Tangibush.
Ms. Bush, what's your full first name?
Tangelita, Tangelita.
Are you a member of the Georgia Bar?
Yes, ma'am.
How long have you been a member of the Georgia Bar?
Since November 10th, 2016,
And where do you work?
at the Fulton County District Attorney's Office
How long have you been at the DA's office?
for 2 months.
Now, Ms. Bush, this panel has heard testimony that you used to work with Judge Williams. Is that right?
That's correct.
When did you begin working with Judge Williams?
In January of 2021,
What was your role?
judicial staff attorney.
And when was your last day of work for Judge Williams?
October 15th of 2021.
So you started January 1st, 2021. Were you Judge Williams' first staff attorney?
Yes,
You started day one with her?
yes.
Do you know whether Judge Reeder served in the family division for the entirety of her term on the court?
I believe she did, but I couldn't answer that confidently.
Okay. How did you get your staff attorney job with Judge Williams?
A friend of mine sent her my resume. She knew she was looking for a staff attorney.
Did you know Judge Williams before starting with her?
No,
Had you appeared before Judge Williams?
no,
Did you have prior experience as a staff attorney?
yes.
Tell the hearing panel about your prior experience.
Yes, so when I was first licensed in November of 2016, I started that next January working as a judicial staff attorney in Clayton County. And I stayed there for 2 years. And then I came to Fulton Superior Court working for another judge as a judicial staff attorney for 2 years. That was supposed to be a temporary position, but it lasted for 2 years.
Which judge was that?
That was Judge Glanville.
What time period was that?
October 31 of 2018 to around September of 2020.
Was Judge Glanville in family at the time
Yes.
that you worked with him? Do you recall who the other judges were in family at the time you worked with Judge Glanville?
Judge Schwall, Judge Brasher, perhaps Judge Reeder at some point. I know there are different cycles. I'm probably missing someone, but
Okay. Before joining Judge Williams as a staff attorney, did you have prior experience in family law?
yes.
Okay. Tell the panel about that.
So as a staff attorney, you handle most of the civil or domestic cases. You will get some criminal experience, but a lot of times the civil cases fall on the staff attorney to move forward, read the motions, ensure that they are heard, etc. So that was pretty much my whole career prior to Judge Williams.
Okay. When you mentioned you worked with Judge Glanville and he was assigned to family at the time.
Yes.
Okay. What was your job as a staff attorney, Ms. Bush?
So as a staff attorney, we assist with case management, legal writing, research, a lot of front house work, sometimes more of a community service and customer service role. They get to you before they get to the judge. So it's a little bit of everything, but essentially the job is to keep chambers moving and the cases moving. You assist with the team.
What role, if any, did you play with respect to getting orders out?
So there were, having that much experience prior, I had every order I'd ever drafted. So many times, if there was a hearing and an order needed to be drafted, I would either have a template already ready, and at times Judge Williams would say, can you please make sure this order gets out, or give me the order, so I can review it. Judge Williams also wrote her own orders as well, and sometimes she would just have me as a second set of eyes for grammar and agreement, etc. So an integral role, but I was not the only person writing the orders necessarily.
Okay. Was that different with Judge Williams writing her own orders? Was that different than other experiences that you've had as a staff attorney?
No.
So this panel has just heard about the judge's beginning caseload when she started in January 2021. And so my question to you is, when you were with her on day one, first of all, have you seen caseload summary reports?
Yes.
Okay. How did you approach the state of the docket when you began on January 1 in your role as a staff attorney?
Well, I'm very type A. So before I actually got there, we pulled a case list to see what the universe looked like, because I think that the harder part about managing the cases is knowing what your universe even looks like. And so on day one, we had a pending case list, and I think there were about 800 cases, maybe a little shy. And we looked at what was like the time intervals regarding the cases, what needed the most care first. And then we moved from there.
How would you decide what needed the most care?
Well, in family, you have some that are emergency issues, but a lot of times you're looking at things that are taking longer than you believe they should. Like if they're still pending, because Judge Williams was taking over for another judge, because the division just takes on a new head, but the cases remain with the division, if that makes sense. So sometimes there was a reach back of asking, hey, what's going on in this particular case? Because we see it's been pending 12 months, 13 months, et cetera. And, you know, to our knowledge, you wrote the order. We need to know how to move forward.
Okay. Did you have a particular approach with respect to the cases that appear in this last column that have been pending for more than 18 months?
Those are always priority.
And what does that mean?
Scheduling and maintenance. So part of reviewing the caseload, you look to see the last hearing, last paperwork submitted, last issue. Is it something that is waiting on us to move? Something that we are looking for parties? We need something from attorneys, or we need something from a pro se party, et cetera.
And how was Judge Williams involved in that process?
She was involved. She was, before we started, she actually sent over, she had already looked at her caseload beforehand and had broken down what her caseload looked like, including over 18 months, types of cases, et cetera.
Okay. When you received this monthly report, excuse me, this one as an example, what do you do with it? What did you do with it during the time you worked with Judge Williams?
Well, so at a certain point, I learned how to pull the caseload myself. So this was never news. We kept an eye on the universe to start, but that started when I first came to the family division in general, when I realized you're going to keep getting cases, but you will not have it. You won't know what's out there unless you're just regularly pulling what your caseload looks like. So most of the time, this is just reinforcing what we already had in front of us, and so we could understand what work needed to be done, including scheduling, orders, et cetera.
Ms. Bush, did you experience any challenges in performing your job as a staff attorney with respect to the workload?
No, I would say I was great at my job.
Okay. Do you recall any issues with delayed orders during your time as a staff attorney with Judge Williams?
So, yes, but what I will say is that, again, you're walking into a caseload that exists. So I would say with the division, in the sense that there were cases that we walked into that there had either already been a final hearing on, but no order had been issued. And so we had to reach back to get orders. I was only there for 10 months, so there was not a time frame really that I experienced. Something happened in January. In October, it's still not resolved per se.
Okay. You just mentioned that you were there for 10 months. How did your time with Judge Williams come to an end?
I had a better job offer.
Did you participate in the transition to the new staff attorney?
I did.
How so?
So the new staff attorney was starting, I don't know what her original start date was, but I know we overlapped for a week so she could shadow. I knew that the attorney coming in was very experienced as an attorney, but not as a judicial staff attorney, which is just a different ballgame. And I created a set of documents that I sent to the new staff attorney and remaining litigation manager and Judge Williams that had 15 or 16 documents attached to it, including a case list, et cetera, all of the things that they kind of needed for transition, so there wasn't a gap there. And I also left myself open for the new staff attorney to call me, which she did a couple of times when things were hectic and she's, stuck in trying to do something.
Okay. Was Judge Williams involved in that transition process?
Yes.
How so?
Well, she ensured that we overlapped for a week. She checked in to make sure that the new staff attorney was getting what she needed, anything that she would kind of think of. And otherwise, she was always kept aware of what was happening.
Okay. You mentioned, Ms. Bush, that the judicial staff attorney job was a different ballgame than being an attorney. How so?
Well, you're managing a caseload that is a bit wild sometimes, and the expectations are as if you are working on a team of 20 and not a team of 4. And so you are moving as fast as you can. You're also still serving the citizens of the jurisdiction, and you don't want to get it wrong. So I think that there's just a very high volume, a level of anxiety that can come with it at times. But once you get it and you understand what the needs of the courtroom are and what your needs of your particular judge may be, I think I could be a staff attorney in my sleep at this point, but I understand when I first came in, it was an uphill climb trying to figure out what it needs to look like every day.
How long did it take you to get it?
6 months.
Oh, goodness. And you started, I didn't mean, oh, goodness.
It's
I'm
fine.
sorry. But six
It's-
months? Okay.
It's fine.
So at this point, you haven't worked with Judge Williams in over 3.5 years, right?
Correct.
When's the last time you spoke with Judge Williams?
That same year, 2021.
What was the occasion?
So at this point, I was no longer employed with her, but while I was there, I did have our youngest son, and she just reached out and asked, "How's my little man doing?" Maybe about a month or so after I wasn't there, and so I said he was great. He was eating me out of house and home, but that was about it.
Okay. Let me switch gears here. This hearing panel, Ms. Bush, has heard evidence from Brandy Alexander about some specific statements she attributed to you. I want to talk to you about some of those.
Okay.
Well, first of all, are you aware that Ms. Alexander testified in this case that you said certain things to her?
I am.
Okay. How did you become aware?
I was watching the testimony in real time.
Had you been subpoenaed as a witness at that time?
No.
Okay.
I'm going to object and ask that we take this issue up with the agreement panel. The panel very clearly instructed the lawyers to instruct our witnesses, and then the panel gave a very clear instruction for anybody watching the proceeding.
We did.
Ms. Bush was not a witness at the time. We had not decided to call her in this case. We actually now are calling her in rebuttal to Ms. Alexander's testimony. We didn't have her under subpoena.
Wasn't she on your list of witnesses?
She was on our earlier list of witnesses, but she wasn't on our final will call list of witnesses.
She said they're calling her in rebuttal. This is not rebuttal. This is
Well, hang on, let me just get to the witness list. All right, so she appears on the director's list of witnesses to be called at the final hearing in the second set of charges. And then she also appears on the judges intended to be called at the final hearing list as entry number 8.
Yes, and we subsequently provided the director with a list of our witnesses. And we had decided not to call Ms. Bush at that time, and it was only until Ms. Alexander's testimony that we decided to call her. And rebuttal, again, we're about to get into the rebuttal pieces of the testimony, which goes to the weight of the credibility for the director's key witness.
Response?
I think it's a problem that a witness has watched prior testimony and then comes in to give their own testimony to rebut what they said and watched. I have a major concern with that. But, at this point, I don't know that the panel would preclude her from testifying about what she had observed, but
And she can be crossed on her testimony.
Well, I guess the problem is we gave very clear instructions. You all both decided that you wanted to invoke the rule, which we did as we traditionally would in the courtroom. And because this was being live streamed, we gave a specific instruction over the live stream, but we also gave instructions to you all to instruct your witnesses. I get what you're saying, that she was a potential witness or wasn't a witness that you all intended to call at that point. But I don't know that makes that big of a difference to the panel. This seems to be a direct violation of the instruction that the court gave. I guess the question I have is, given the position that the respondent's taking on rebuttal, and this is someone we didn't, is this going to happen with 3 or 4 or 5 more witnesses who've also watched live stream testimony, or is it just peculiar to this particular witness?
It is particular to this witness. This witness wasn't given an instruction not to watch because we didn't intend to call her. I don't know whether she heard the, Your Honor, say don't watch, but she would not have known that she was a witness at that time either.
Okay. Well, I'm not going to disallow the witness, but I guess everybody just understands that the testimony obviously is considered against the backdrop of the fact that she's had an advantage that no other witness has had in this case, as far as we know, which is have watched the testimony that she's being asked to rebut. So I'm going to allow the witness with that proviso.
Okay. Thank you. So, Ms. Bush, you said you heard Ms. Alexander's testimony about attributing certain statements to you, right? What was your reaction to the testimony? Can you speak up just a little bit? Okay.
I was shocked
Why were you shocked?
because that just is not the nature of the conversation we had. I don't understand where that came from in that way.
What do you
help
mean by
me?
that?
I have no memory of what we're talking about. Give me
Sure.
a sentence of what it is this person said or didn't say.
So, well, I'll ask you first, and then we can go through some of the specifics.
Okay.
What stands out to you? What were you shocked by?
I understand it's already happened in this water under the bridge, but instead of having the witness walk through what she heard, I think it would be more appropriate to have Ms. McFadden ask specific questions about the specific statements as she recalls them versus the witness.
I'm happy to do so.
Yeah, I think that's better.
Ms. Bush, Ms. Alexander testified that, and I'm quoting here, if she gets cadence in change, let me do it this way. I have the transcript.
They have the transcript. But we,
Let's start at page, page 515. Do you see the testimony that starts at line 15?
I do.
Well, let's move up a little bit. Trying to give you some context here. You feel free to read. You can see it well?
Yes.
Okay. Miss Alexandra says she ends up talking to someone in chambers, and she identifies you. Well, she identifies Tangi. See that?
Yes.
Okay. And I'll represent to you, this is the director asking the question. And what did she say about why? Why being not to allow her daughter to go back to go back with the judge for an in-camera inspection. I'll represent to you, that's the context that is up above, okay?
Okay.
And Ms. Alexander is saying it's widely known that the judge favors dads, and Tangi kind of doubled down on that. Did that happen?
No.
Did you have a conversation with Ms. Alexander?
Yes.
What was the conversation?
She called stating that she had a case in front of Judge Williams, and she had a list of concerns that she rattled off in the beginning of the call. Part of those concerns were that the father of her child is what she describes as charming and handsome, and she felt like that would be an advantage in whatever hearing that they had coming up. She stated that everyone knows that Judge Williams favors dads, and she was afraid that he was going to have an advantage. Again, I don't know the crux of the issue other than something regarding custody. But she had a list of concerns there. So that's why I thought it interesting that this is the statement that she made to me compared to the statement that she's presenting to the panel. I did not say that she was a dad's judge.
How about this? If she being Judge Williams, gets cadence in chambers, what she tends to do with children is have them say nice things about their dad. Do you know that to be? Did you say that to
No.
Ms. Alexander?
No.
And she uses that to essentially say why dad should get custody. Did you say that?
No.
And goes on, and the only way that I should agree to allow cadence in is if she agreed to have a court reporter there. Did you say that?
No.
Would there need to be an agreement by the judge to have a court reporter there? Is it?
No, and that's what I said. I don't understand why this was presented this way. What she presented to me was that there was talk of an in-camera inspection, and she asked 2 procedural questions while we talked. Like, I listened to her sounding like someone in crisis, and she asked 2 questions of me. One had to do with how senior judges come to be in cases, and I ran down a list of scenarios in which a senior judge could be called in, but also that it could be discretionary depending on whatever issue it may be. I've learned also not to necessarily ask additional questions when I don't want to. I didn't want to know what the issue was with her and her baby's father. Second thing is, she stated that there was a talk about in-camera inspection. And she said, who is allowed to be back there? And I said, it's always the court reporter. And I said, the only time that issues have ever come up is when attorneys have insisted that either a transcript needs to be filed immediately or that they also need to be present. And I said that that completely defeats the purpose of the in-camera inspection. It's always the judge and the court reporter. And that's all that we said about that. So the presentation here is something completely different.
Has it ever been your experience where Judge Williams gets kids to say nice things about their dad and then uses that to give dad custody?
No, I've never, not only experienced, I've never heard that.
Ms. Alexander says, I had already been told by Tangi that if there wasn't a person in there with her, it was going to go badly for my daughter and me. Did you ever tell Ms. Alexander that?
No,
Anything like that?
no.
Do you know why Ms. Alexander might say it? Do you have, based on your personal knowledge?
I have tried to figure out why.
Okay,
It's fine.
sustained.
Did you know Ms. Alexander? Do you know Ms. Alexander?
Yes.
How do you know her?
So I met her as a guardian. She was, I was in Judge Glanville's chambers and she submitted an email. And I don't want to say soliciting, but making it known that she was going to do guardian work. And so Judge Glanville brought her in, met with her, and started to assign her for guardian ad litem work within his courtroom first. And that's where I first met her.
Were you friends?
I wouldn't say friends. We were colleagues. We were familiar. But I use the word friend very tightly.
Had you been to her house?
No,
She been to your house?
no,
Had lunch together?
no,
Dinner?
no.
Are you familiar with her reputation?
So yes and no. As a guardian, she was known. She actually had a lot of guardian ad litem cases. She seemed well intended. She seemed to work pretty quickly. She was also very nice. Otherwise, professionally, there wasn't anything detrimental there.
Ms. Alexander represented that the two of you talked a lot back then. Was there ever a time when you talked a lot?
No,
How often did you talk with Ms. Alexander, say, in 2022?
I probably talked to her about 2 or 3 times, and I'm being generous with the 3. We did not talk on a regular interval or anything that I would consider a lot.
What about, even if not talking, texting? Did you text a lot?
No.
The conversation that you testified about where Ms. Alexander asked the procedural questions, when did that happen?
So it had to be, because I was gone from Chambers, no longer employed there, but it had to be the first, maybe 3 or 4 months of 2022. Because I at that point had not had, I don't know that I had talked to her since I had left Chambers. And so she reached out sometime around that time frame.
So you were
Where-
no longer the staff attorney for Judge Williams?
No longer.
Do you know where Ms. Alexander worked at that time?
To my knowledge, she was self-employed. I don't know if she was working for a firm otherwise.
Okay. Where were you working at that time?
At a nonprofit.
Okay. Let me ask you about some other statements that Ms. Alexander attributed to you. Well, before I do, did you only have the one conversation with Ms. Alexander?
No, there was at least a second conversation, and I say that only because she called about something else. It was not directly after the first phone call, but a completely different topic, and as an aside, that's when she let me know that Judge Williams had recused. She volunteered this. I was grocery shopping at the time. And so she volunteered, oh, by the way, she recused.
Okay. Do you recall when that was?
I don't.
Okay. Was there further conversation about that?
No.
In your time as staff attorney for Judge Williams, did you ever see her make a phone call to a litigant ex parte?
No.
Are you a member of a sorority?
No.
Did you ever hear Judge Williams talk with litigants about being a member of a sorority?
No, not with litigants. We knew she was in a sorority, but that wasn't the thing she led with necessarily.
How did you know she was in a sorority?
Well, when you're a staff attorney and when you were in chambers, I was there while she was decorating, at least on Zoom, so we knew why there were elephants in the office, so it wasn't hidden, but I don't think that she led with it with litigants necessarily.
Did you ever hear Judge Williams refer to someone as soror?
Not that I can recall, but
Ever hear her say anything about on the shield?
no.
So I was asking you about the statements that Ms. Alexander attributed to you. Ms. Alexander says that you told her not to let her child go in there. Did you say that?
No.
Anything like that?
No.
And that Ms. Alexander says that Judge Williams would weaponize this against you if you allowed your child to go in there.
No.
Have you ever been contacted by the JQC in connection with the charges against Judge Williams?
No.
Not by an investigator with the JQC?
No.
Not by the director?
No.
Would you have talked to a representative from the JQC if they had called you?
Yes.
Would you have expected the JQC to call you if they were aware of the kind of statements that Ms. Alexander attributed to you?
I would think so.
Why?
So I know I've only been a prosecutor for 2 months, an attorney a little longer. I think if I'm available, you want to also know what else I have to say if my name is going to keep coming up. I don't know how else you get a full story if you don't include the person that keeps being mentioned. I'm not a ghost. I've been here the whole time.
Okay. Some other statements attributed to you that were not a part of the hearing, but I just want to ask you if you said these things or not.
Okay.
Okay. Ms. Alexander represents that you absolutely cannot take this case in front of her. She will weaponize it against you, and you will never get another guardian case. Did you say anything like that to Ms.
No.
Alexander?
No.
Ms. Alexander also said that you said all of Fulton County would know her business. Did you ever say anything like that to her?
No. She actually expressed a concern. So part of the list of grievances is she didn't want people in her business, which I could understand, but these were her concerns and her statements.
Ms. Alexander says that after she talked to the person from the judge's staff, who would have been you, that you said, don't send Cadence in there. I think we talked about that one. You never told Ms. Alexander not to send Cadence, her daughter, in with the judge?
Correct. I did not say that.
Okay. Has anyone from the JQC ever asked you whether the statements that I just made were true?
No.
You mean the investigative panel?
The investigative panel, the
Thank you.
JQC investigative
I've let it
panel.
go up until now.
I will correct myself. Have you spoken with Ms. Alexander about what she told the hearing panel? I mean, the investigative panel?
No.
Did Ms. Alexander talk with you about the possibility of a senior judge handling her case instead of Judge Williams?
What she asked was, because I guess her and her attorney wanted to file a motion to recuse, but they wanted to request a senior judge. And she ended up asking, well, how does a senior judge come to be? And that's when I listed the scenarios in which a senior judge, at least in my tenure, in which they've been used.
What did you tell her?
So a lot of times it's discretionary depending upon if the caseload is too crazy. Many judges will bring in a senior judge to hear certain motions, et cetera, in another courtroom to get things and keep things moving. Sometimes there are other occasions where not necessarily a motion to recuse has been filed, but to create some distance at a certain point, or certain parties, you know that you're going to be dealing with high conflict in the way the schedule is looking, the senior judge is available to handle certain things. Sometimes that will be assigned to a senior judge depending. It also depends on how available the senior judges are, because their availability, they're out there living their best lives, so they're not always available. So I just listed that those were the possibilities, but I don't know the guarantee of anything.
Okay. In your experience, have you seen a whole case be transferred to a senior judge for handling?
Never.
That's all I have right now.
Ms. Field, questions of this witness?
Give me a second. I spilled some water up here. Clean up.
Mike, do you have a paper towel or something? I spilled some water up here.
It's 11. What time you break? All right, we just get it with some paper. All right. Set it right there for a minute. I hear Jackson stomach.
Good afternoon, Ms. Bush. My name is Courtney Veal. I'm the director of the JQC prosecuting this matter on behalf of the Commission's investigative panel. Appreciate you being here. I've just got a few questions for you. You watched the proceeding and you heard at a minimum Ms. Alexander's testimony, correct?
Correct.
How much more of the proceeding did you watch?
I watched the whole proceeding.
Okay. From start to finish?
Yes.
So did you not hear Judge Burleson's instruction when we began about not watching if you were a witness?
No, I did not hear it, but at that time I wasn't aware I was going to be a witness.
Okay. After you watched the hearing, or during the course of watching the hearing, did you communicate with others about the testimony during the hearing?
Yes, I was contacted a lot.
Right.
I selected which phone calls I took.
Did you speak with Judge Williams about the testimony in the hearing?
No, I haven't talked to her since 2022.
Okay.
Or 2021, I'm sorry.
All right. What about Janelle Bowles? Did you speak to her?
I haven't spoken to her in years.
Okay. What about Brittany Green?
I've never met her.
Okay. Did you talk to anyone that is a witness to this proceeding, to your knowledge?
Yes.
Who?
I was reached out to by Miss Aaron, Attorney Aaron,
Okay. When did she reach out to you?
when Miss Alexander was testifying. She just wanted to ensure that I was hearing it.
So you felt like Ms. Alexander made some false statements?
Correct.
And what, if anything, did you do after, I don't mean talking to your friends and whatnot, did you call either the respondent's legal team or the director's legal team to say, hey, I'm an officer of the court, I just saw somebody lie under oath, I think I need to report it to you?
I didn't call either. I was reached out to by defendant's counsel. I had to sit with it for a moment to figure, because that wasn't the first untrue thing I'd heard, and I didn't understand this. And so I sat with it for about 30 minutes, and I received a phone call from Attorney McFadden.
Thank you.
Mm-hmm.
What did Miss Aaron say to you when she reached out to you?
She ensured that I was listening. Like, are you watching this, essentially?
And that's all she said?
Yes.
What did you say in response?
I said that I cannot get my words together. I don't know what is happening. I don't even know how to clear this up.
How do you know Miss Aaron?
I met her when I was a staff attorney in Clayton. She had one of the first oral arguments when I started working there, so I met her like the second week of in Clayton County.
You spoke on direct about, I took it as different conversations that you had with Miss Alexander about the case she had pending before Judge Williams. How many conversations do you believe that you had with Miss Alexander about her case before Judge Williams?
There was only the one full conversation as referenced with the procedural questions, and then there was another conversation about something completely different. She called to ask questions about something unrelated to law, and she added as an aside. So I wouldn't say two full conversations, but those were the times in which that was discussed.
Okay. Her inquiry to you about a senior judge and obtaining a senior judge, that would have been during what you characterize as that initial conversation where you all were discussing procedure?
Correct.
Okay. What was the last day that you worked in Judge Williams' office?
October 15th of 2021.
At the time that you spoke with Miss Alexander about the senior judge issue, do you know whether that inquiry had already been made to Judge Williams' office?
I have no idea.
Okay. But tell us again what you recall her questioning about the senior judge issue.
She just asked the circumstances of which a senior judge could be brought in.
Okay. Were you aware that her attorney, Miss Franklin, called and inquired of Judge Williams' office on October 18th of 2021 about that procedure?
No.
What did you tell Miss Alexander about how Judge Williams handled having children come into her chambers?
I just told her that the court reporter was the person that could come in the room because she asked who could be in there.
Okay. Did you tell her anything else about the manner in which Judge Williams handles those situations?
No.
So your only comment was the only person that can be in there is a court reporter?
No, what I told her was that the only person that is normally in the room is a court reporter. The only time we've had issues is when an attorney either wants a transcript filed immediately, or sometimes attorneys will want to be in the room, and that defeats the purpose of the in-camera inspection, as it's supposed to be the judge and the child speaking.
And you didn't in any way discourage her from allowing her child to speak with Judge Williams?
No, for in-camera inspection, I'm not even in the room. I've never heard to date of Judge Williams or any judge that I've worked for coercing a child at any moment in an in-camera inspection. If anything, it's when they're the most human, no knock on judges, it is just they're talking to a kid. And it's normally just to find out where the state of mind is for the child, if they know kind of, is there discord in the house, do they even speak about that type of stuff, et cetera, are they happy? Those things. It's not a formal inquisition. It's not, and I'm also not present. So I've never had a litigant complain after that something nefarious or otherwise malicious occurred in an in-camera inspection, et cetera. So I didn't have an opinion otherwise.
Okay, and your testimony on direct was that you did not make any statements confirming that Judge Williams was in fact a father's or a dad's judge, correct?
That's correct.
Was she a dad's judge?
I've never seen her make custody decisions based upon gender.
Okay. Are you aware of whether she had a reputation as a dad's judge?
When Brandy said it, it wasn't the first time I'd heard it.
And you said you and Miss Alexander were colleagues and familiar, but you never exchanged text messages and never went to each other's homes.
I didn't say text messages. What Attorney McFadden asked was at a regular interval. And I said I did not communicate with her at any different volume of interval or anything that was outstanding as a high volume or all the time as attributed.
All right, you indicated, just switching issues here, you indicated that when these case reports were sent out, it was generally information that you were already aware of, correct?
Correct.
You had figured out how to get this report information, is what you testified to.
Correct. While I was working in a different family division, I went and found the gentleman who pulls the reports every month and asked, how do I pull our numbers? Because we could wait a month to get the numbers, or we could know at any given time.
Okay. So that would have been when you were working for Judge Glanville. You figured out how to do that and
Correct.
started doing it. Okay. When you were working for Judge Williams, how often did you do that on your own?
Probably every 6 to 8 weeks.
And then the case reports were sent out monthly?
Correct.
When you did it on your own, what did you do with the information from the report?
So I would go through and I would go case by case to see the last action or event on the case to see, is it the case that a final order was filed, but for some reason the clerk's office hasn't shown it as closed? Was there a hearing, a 60-day hearing on this matter, and we need to schedule it for a 120-day hearing? I would look to see procedurally where we were at, and if we needed to do a thing, or if we're waiting on attorneys to do a thing, to just keep things moving.
Okay. And the process you described, you would do that for all cases, or you would do it for the cases that are listed as they have been pending for longer than 18 months?
No, I would do it for all cases. On my last day, I sent a case list, but I could only get to the first 200. So that was the only unfinished case list that I've sent out. But there's like 200 and change that were annotated where you could see where the last hearing was, if there was pending, final paperwork, if it needed to be scheduled, things like that.
Where did you keep that information? Did you make like a spreadsheet?
No, well, I would just send it. I would send it between chamber staff. I made it on my computer and I would send it.
You made what? Was it just like?
Oh, I'm sorry. So when you pull the case list, it comes out as a PDF that's like several pages long.
Okay.
So say you have 800 cases, 800 cases, you might be dealing with 35 pages, right? Because they're maybe 20 or so to a page. And so I'd go through and just annotate the PDF.
Okay.
So it was easy to read and easy to kind of keep up with.
Okay. And you said you shared that with the staff in Judge Williams' office.
Correct.
Did you also share that with Judge Williams?
Correct.
Okay. And then when these reports went out monthly, Judge Williams also received them, correct?
Correct.
Okay. You said, it sounded like what I took from your testimony was that Judge Williams was very involved in overseeing, if you will, her cases, and you testified that she would make sure on the cases that had been pending for a longer time that she would make sure that you guys got an order out, correct?
Correct.
Okay. And you testified that Judge Williams would also write some of her own orders?
Correct.
Okay, what, if you had to guess, was the breakdown? Did you do 50% or more?
Yes.
How many do you think you did percentage-wise?
Oh, God. The family division has a lot of orders, so I don't know how to. There are definitely hundreds, if not thousands. I mean, it really is very high volume. I don't know that I can give an accurate estimate, and I don't want to give it an accurate number.
That's okay. More or less than half of the orders that were done during your 10 months there, do you think you did more than half of them?
Correct.
Okay. 75% of them?
So I teeter at that number solely because if you had a case that had an attorney or attorneys, because of the volume, many times you would ask to please submit a proposed order. Just help us help you. So I can't say 75% as if there was not also an inflow and contribution, at least coming from that. But most of the litigants in Fulton Family Division are pro se. So that wasn't most of the time, but it was a decent flow.
How did Judge Williams decide which orders she was going to do and which ones you were going to do?
I don't know. I don't know that there was a rhyme or reason necessarily, other than perhaps maybe it's something she was already working on, or I don't know.
Okay. Who was Judge Williams' JO during the time that you were her staff attorney?
Her name was Fatima Harris Felton.
And did Ms. Felton also do some of the orders?
She had to do all of her orders. So just to elaborate for the panel, that means all of the cases that are heard at 30-day or 60-day conferences that would have been in front of J.O. Felton, she would have been responsible for whatever orders were filed with that.
You indicated that you assisted with Ms. Bowles' onboarding, correct?
As much as I could, yes.
Oh, okay. And did you share with Ms. Bowles how you would, independent of the case reports that were sent out monthly, how you would go in and pull the cases yourself?
I did. Like I said, I'm type A. So I made a how-to manual because I felt like when I became a staff attorney, it was Godspeed. And so on that are screen grabs of the actual procedure to not only pull the caseload, create calendars, etc. Because I just felt like that was a harder hill to climb and also keep up with the volume when you could just have something at your fingertips to kind of walk you through.
All right. If I could have 1 minute, please. Sure.
Did you get calls from lawyers asking the status of their orders?
I did. Emails mainly.
And what would you do what would be your normal procedure when you get an email from a lawyer?
Like anything else, you look the case up because sometimes there are attorneys that we were in court on Thursday. Why is our order not filed on Friday? But you look the case up, and a lot of times I would see, are they waiting on us or did they submit paperwork that for some reason hasn't been filed? From there, either we get them calendared, scheduled, or we would make sure that the paperwork was filed. I realized coming into the Family Division in Fulton, a lot of the ire came from a lack of communication, sometimes between chambers and attorneys that are working on cases. And so I tried my best in the years that I was judicial staff attorney there to make sure that they always at least knew, to the best of my ability, what was going on with their case. Because I think sometimes with knowledge, you at least know we're trying to get to it, or we're writing the order, you just got to give us 7 more days to get it finished and filed, that type of thing.
Was there a point you would go to the judge on any of those and say, this one's been X number of days, maybe it fell through the cracks, or were you the watcher of the cracks?
No. I communicated about the cracks because ultimately my signature means nothing.
Right.
It's important for my checking account, nothing else.
Right.
So, yeah, I can only do so much. So it was a dialogue. Especially, sometimes it would depend on the circumstance, because like I said, there was a lot of emergency situations in the family division. And so we can't wait till Friday to file this. This has to go in Wednesday because Friday a custody exchange has to happen and we don't want that to go awry, that type of stuff. So I was not just the watcher of the cracks.
Thank you.
Okay.
Anything else?
Ms. Bush, you testified that Judge Williams had an incoming caseload of about 800, and the panel saw on the January 2021 report a number of about 636. Can you speak to the difference between those numbers?
So yes and no. Just because I don't know what happened in that time frame. What I will say is usually within the family division, you were getting anywhere from 100 to 125 cases a month, and you would hope to close between 100 and 125 cases a month. So a lot of times the number was staying stagnant or only moving gradually. In turn, though, the goal is to have a lower case number, meaning that you have resolved many domestic issues within Fulton, right? So I don't know the work that was done between that time frame and the 600 number, but something had to occur to get down to that.
Do you know whether the 600-something number included the post-judgment, the post-family judgment matters?
I don't know.
You know if those numbers had to be pulled separately?
So I will say this, when I pulled numbers, they would all be together. So because it's again assigned to the division, it's pulling for the division. So it's not separating, this is a post-judgment matter, this is this type of filing. It is just, these are all of your cases.
Okay. You mentioned that you drafted some of the orders for the judge. Would the judge make revisions to the orders that you drafted?
Absolutely.
Can you tell the panel about the extensiveness or not of those revisions?
She was very hands-on. I will say she read anything that I sent to her. Hey, Judge, look at this. It's ready to file. She might go in there sometimes and add certain provisions that she knew from a hearing to prevent issues that may come forward, et cetera. Sometimes she would go in and she would always read from top to bottom whatever was sent to her and revise as necessary.
How often did the judge just take a draft order that you wrote and sign it?
Never.
Okay. Another question about the monthly reports. They don't show the orders that are outstanding, right?
They do not.
When you would get the inquiries about the status of the orders that you talked about, would you share each of those inquiries every time with Judge Williams?
It depended on where we were. So most of them were shared, but if it was I know we've already got this order pending and I just need to file it, I'm trying to file it now, or it's getting rejected, or I just need to walk it down to the clerk's office because some are more sensitive than others, I would just give the attorney the update and say, hey, I'm taking care of it now, and follow up to make sure they got a service copy of it. But most of the things that were pending, if we were getting communication, we follow up. It was a dialogue within chambers in general.
Okay. Were you aware that, just to clarify for the record, I don't know that I said this, were you aware that Brandy Alexander set for a recorded interview with the JQC's IP panel in June of 2022?
Not until being called for this hearing.
Are you aware of whether Ms. Alexander attributed certain statements to you during that interview?
To my knowledge now, yes.
Okay. And did the JQC ever ask you whether those statements that were attributed to you back in June of 2022 were true?
No.
Okay. There was some conversation about you being on the director's witness list for this trial. Do you recall that?
No.
Do you recall? Assume you were on the director's witness list for this trial. Were you ever given an instruction by the director's office, the JQC investigative panel, the director's office, about not watching the hearing online?
No.
Okay. That is all I have. Thank you.
Anything else for this witness?
Ms. Bush, I never reached out to you, you were never subpoenaed by the JTC for this hearing, correct?
Correct.
Okay, and have you read the formal charges in this case?
I have.
You're not mentioned anywhere in there, correct?
Correct.
Okay, and none of the charges in any of these, in either set of formal charges relate to anything that you were a witness to, correct?
Correct.
Okay, thank you.
Yes, ma'am.
All right, you guys got anything else? Okay, just out of curiosity, I know you said you worked in Clayton County. Was that in Superior Court also?
Yes, ma'am.
Who'd you work for in Clayton County?
Judge Robert Mack.
Okay. And so I am not familiar with how Clayton divides things. Do they hear a little bit of everything? So they hear criminal, domestic, and civil?
Yes.
So
Yeah.
you did a little bit of everything with Judge Mack.
So with Judge Mack, he handled criminal. He was a criminal defense attorney for about 20 years before he was on the bench. So criminal, he could do in his sleep. And so for 2 weeks out of the month, that was his 2 weeks for criminal, and the other 2 was civil. And usually I at least moved those cases forward, handled drafting the orders. Obviously, he would also participate, but the civil and domestic matters were mainly where I came in.
Okay. And so when you started in Judge Williams' chambers, that was your third tour of duty as a staff attorney.
Correct.
And I know that you mentioned that you've got the monthly reports, and then you did that annotated PDF as well.
Correct.
And that annotated PDF, if I understood you correctly, that would have flagged things that had gone past 90 days, that y'all were the ones that somebody might have been waiting on an order.
What it would
Correct.
show, I'm so sorry.
No, go ahead.
What it would show, so the way that the PDF, when you pull the report, obviously it shows the initial number, so you know which line you're looking at, the case number, and it shows the filing date. So it doesn't distinguish on its own what's been pending for 18 months, but you can see the date when it was filed. So from there, you could see what our 18 months cases look like and kind of where the last event on each case next to it, or each case next to it.
Could you easily see, though, or did you have through that process or some other program you had access to, could you easily have pulled, okay, these are all the cases where a motion's been filed or a final hearing's been had and an order is outstanding, either that we're expecting from attorneys or that they're expecting from us?
No.
How did you all keep up with that? Because I can imagine at the volume we're seeing, that could get lost very quickly.
Like I said, I was very type A because I knew there was no way for us
I
to
figure
pull
you
that.
have a system. I'm just curious to know what it is.
You have
based
to,
on
or
what
you'll
you
get run
described.
over.
Okay. So how did you keep up with that so that, y'all weren't letting things fall through the cracks, as Mr. Hyde said?
Aside from the annotated case list, so with each calendar, so we'd have, say you have a month of calendars, your motions calendar, final hearing calendar. I have calendars, all of the PDF versions are annotated, or when I was handwriting, they were all written and tabbed. So we knew, like I would put tabs where orders were due, or I would say order due out by. And so I would keep track going forward, noting what the next step should be in this case, and also looking back to reconcile, have we done everything we're supposed to do to keep it moving forward? So it was a kind of a dual system.
Yeah, no, I gotcha. And so would you say that using that system that you kind of set up for the chambers, did that tend to help you guys run more ahead of the game, or did you find yourselves running behind, or how well did that work?
So I do think it worked well, but I think that the way that the system is kind of set up, you're behind, you're reactive anyway, because you're already coming into cases that are filed and at different intervals in their matter.
Sure.
And so where somebody might take the bench January 1, they're still coming into the family division with all of the cases that might go back a year or two. And so I think it helped to tread water and get a little bit ahead, but I don't know that there's a foolproof way to get completely ahead unless you just had more hands and more time. Because you can't slow down the case filing speed or the interval that the cases come in.
Sure. Okay, thank you. Anybody else got any other questions for Ms. Bush before we let her go?
No.
Nope.
Just one more.
Yeah, go ahead.
Were you aware that there is a statute in Georgia that requires judges with certain population sizes, in Judge Williams' case, to rule within 90 days of a motion being either submitted without argument or being argued. Were
Yes.
you aware?
Yes.
You were aware of that?
Yes.
Okay. And is that part of how you were tabbing off and marking, like you mentioned, I would tab off, like this is when an order is due?
So the 90 days mattered, yes, but if, say, the hearing was today, we'd give it 10 days, 14 days. We try to make sure, because 30 days is a long time for, family to be sitting and waiting to see who's getting medical decisions or something like that. So there would be 10 days, sometimes 14 days, and depending on the circumstances, it might call for a little more time, but usually a time interval was communicated to the litigants, and we'd go ahead and write that down and do our best to make sure that happened in that time interval.
The 10 days and the 14 days, was that time frame, which is much quicker than 90, was that imposed by Judge Williams? Was that her rule?
Well, it was a, I wouldn't say a rule, but it was certain things that she would say from the bench. Hey, I'll get you this order out in, and usually it would be a very brief interval. And so that just became kind of the thought in chambers that there, of course, is case law and statutory law that requires these things, but this is the time frame that she's operating on.
Okay, all right, thank you.
Yes, ma'am.
Yeah, go ahead.
Ms. Bush, in your tours of duty, especially with respect to family law, are you aware of any judge other than Judge Williams having taken more than 90 days to issue an order?
Yes.
Thank you.
All right, thank you. You're free to go. All right, why don't we take a quick 15-minute comfort break? Two things, though, before we break. Number one, it has come to my attention, and I did not see it, that someone in the audience may have been taking a photograph or recording something. I have received no Rule 22 requests for today other than the previously filed one from the AJC reporter that I had told y'all about. So please understand, if you're a spectator, that no one should be recording or taking photographs or anything. Obviously, that would be a problem without first getting the panel's permission. Second thing, if it hasn't already become clear to everyone, let me just say it now. From here on out, if there's anybody who's a witness or even a potential witness, I am instructing both sides. You all need to instruct those folks. Can't do anything about what they may have watched before, but from here forward, they don't need to watch any live stream until they have testified and been released from their subpoena or just released from consideration as a witness. And they certainly don't need to talk to anyone who might call them to tell them about anything that that person may have seen. So please instruct your witnesses and any potential witnesses accordingly. With that, we will take a 15-minute recess and be back to start with whoever the next witness is. Okay? Y'all can have a seat. If you'll call your next witness, please. Okay.
Good afternoon.
Good afternoon.
You raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
Thank you. Would you please state your name for the record?
Sit down.
Yes, please.
Janelle Bowles.
Will you spell that, please?
Janelle is Janel. Last name is Bowles, Bowles.
Are you a member of the Georgia Bar, Ms. Bowles?
I am.
For how long have you been a member?
This is my 30th year.
Congratulations.
Thank you.
Where do you work?
I currently am at the City of Atlanta Solicitor's Office.
And for how long have you worked there?
I started in August of 2023.
Where did you work before then?
Superior Court, Fulton County.
And what was your role?
Staff attorney for Judge Shermela J. Williams.
Okay. When did you start with Judge Williams?
October 18th, 2021.
And when did you end?
Approximately June 2023.
Okay. Would you tell the panel, Ms. Bowles, how you came to work for Judge Williams?
Well, I learned of the vacancy she had as a staff. She had a vacancy for staff attorney. I learned of that position through some mutual colleagues and determined the application process. And I was actually looking for a job, just kind of in the market for a change from what I had been in, and submitted an application.
What had you been doing immediately before you went to work with Judge Williams?
I was in a private practice. I had merged my practice with another bankruptcy practice.
What was your practice?
I had been a solo practitioner, and also had a partner a couple years during that time frame. But 1999 to 2000 is when I went into private practice as a solo practitioner, and I practiced in the areas primarily bankruptcy, some real estate, some family law, earlier in the beginning, but primarily bankruptcy, personal injury.
Okay. So for 20 years before joining Judge Williams, you were in a solo practice?
Yes.
Okay. Did you have any prior experience in family law, Ms. Bowles?
Very little. When I first started my career as an attorney, I started with a solo practitioner, and I was the first associate hired by that solo practitioner. So that was in 1996. And I did handle divorce cases, some child support cases during that time. And I was there for probably 14 months. So during that time, and it was back, I would say back in the day. It's funny because when I think about the child support worksheet and the calculations and all the things, that we did not have a worksheet at that time. So it was very, very early in the, I guess, mid-90s, late to mid-90s.
Okay. Did you have any prior experience as a judicial staff attorney?
No,
Prior experience in government?
no. Well, no, I was actually, had a part-time position with the Georgia Department of Behavioral Health and Developmental Disabilities. So I did work on a contract basis, handling some hearings, administrative hearings on behalf of GBHDD. But that was the extent of it, but not extensive government, no.
So what about this role that sounds like it was different from anything you had ever done? What about this role attracted you to it, the role with Judge Williams as her staff attorney?
Well, looking for a new pace. I had previously been, like I said, in private practice, and I thought it would be a different pace in terms of environment, working on the other side of the court system. And I was excited about Judge Williams being on the bench, and the opportunity to work with her was exciting.
Why were you excited?
Well, she's representation of who I am, right? It's good to see representation of African American women on the bench. So that was exciting.
Okay. So what were your job duties as a staff attorney with Judge Williams?
So as a staff attorney, you responsible, well, in Fulton County Superior Court Family Division. That's the only reference I can give you for what you do as a staff attorney, because that was the only time I did work as a staff attorney. But responsible for communicating internal and external communication, so communicating within the court, communicating with parties, email, phone communications, research, if there were an issue that needed to research, scheduling, sending out notices, and assisting Judge Williams in preparing orders and filing orders.
Okay. Describe your workload as a staff attorney when you were with Judge Williams.
Massive. One word would be massive. Another word would be massive. Okay, no, seriously. The workload was I think we had at one point we had over 650 cases. And that one division of family was responsible for, so we were responsible for making sure cases were scheduled. On any given day, I may receive, 50 to 75 emails. Phone calls, we may receive about, 50 or so per day. But it was a really high volume of cases.
Was it what you expected it to be?
Not at all.
What did you expect versus what you experienced?
I did not expect that there would be that large number of cases. And I really didn't have an expectation that the caseload was high until there was not really a case management system. Like, I came from private practice, and being in private practice, we had a case management software where if you or anyone else on the staff communicated or did some work about the case, you would have a way to track it, right? Some type of software to use to track it. That was not the case, and so that was overwhelming and quite surprising for me to make that transition and to be in that scenario where we're responsible for that many cases, and we have to know kind of where they are at every moment, right? And then if a party reached out to you, knowing what the status of the case is, how to communicate, and then there were always new cases coming in. So we were responsible for, getting the cases in and then also moving them along kind of the disposition track.
So if there was no case management system when you started, what did you do? What was your process for managing the cases?
So initially we had, so I say we because we work as a team. Judge Williams wanted us to cross-train. So it was a case manager, judicial assistant, and myself, and obviously being the leader of the team, other than Judge Williams, I mean, the only other attorney there, right? So I was expected to basically create a system. So we used spreadsheets. So we identified different spreadsheets with the different case types that would provide a status. And that was what I thought would be best. That was what I created in terms of trying to identify or have a case management system.
Well, let me ask you this, Ms. Bowles. Before you joined Judge Williams' staff, there was another staff attorney in your spot, right?
Yes.
Did that person create a case management type of system as far as you know?
As far as I know, there wasn't a case management system that I don't remember her passing down or passing along a case management system. She did have like a handbook, a mini handbook, and templates, and like email templates, document templates, frequently used, responses, those types of things. So she did provide a good framework, but I do not remember an actual case management system.
Okay. Do you know how the prior staff attorney kept track of the cases?
No. I don't remember. I may have known at that time. I don't recall specifically now.
So you came up with the process that worked for you?
I did.
You just talked about the how-to manual that had some templates, et cetera. Is that right?
Yes.
Okay. How did you use those, or did you use those?
I did use them. It was a good place in terms of a starting point. In the family division, because of the way the cases would kind of progress through the process, at the filing, and then certain things that had to be filed, and then 30 days, 60 day, 120 day status, and then where there was a final, if there was a motion. So some of the information or some of the responses or some of the templates, we could reuse those because it was kind of repetition. It would be pretty repetitive in terms of what needed to be communicated, depending on what this, what status the case was in.
How long, Ms. Bowes, would you say it took before you hit your stride and understood, had a system going that you could use?
That's an interesting question, because quite honestly, I'm not sure that I ever mastered that. I hit a stride of sorts, right? But I do not believe I was operating at the full capacity with all of what was expected from me, if that makes sense. So I got, communication and scheduling down, but in terms of, drafting or researching, those types of things, so those things may not have been all working together at the same time. So, but it was, probably a good 8 or 9 months of being comfortable with what I was mastering.
Okay. You mentioned that a part of your job was to prepare and file orders. When did you realize that was part of your job?
I would probably say it may have been 3 months in or so. and just or maybe a little longer. And not from a standpoint of knowing that I was responsible for filing, but so usually our process would be if a hearing was held or final was held, there may be, if counsel were on both sides, they would present proposed orders. And if there wasn't a proposed order presented, then it's the job of the staff attorney to, from the notes, from Judge Williams' notes, but she took very copious notes, but from her notes or from what may have been, what the proceedings were, would be to draft an order. So, ask me your question again.
Well, let me ask it this way. What was your understanding of your role with respect to getting orders finalized for the court, for Judge
Okay.
Williams?
Right, so if the order, if opposing counsel, if counsel had not submitted a proposed order, judge gave me the option to either request proposed orders from them or draft it if it had not been done by a certain point. And then I would draft it, submit it to her for editing, and then she would give the final back to me for filing.
When did you start drafting orders when there wasn't a proposed order?
I think very close to, maybe like 9 months in or so, maybe 8 or 9 months in. Is that what you mean? In terms of how long had I been there or at what point in the case?
How long had you been there? When did you start doing it as part of your job?
Probably about, I would say maybe 6 to 8 months in.
Well, was the judge having conversations with you about getting draft orders?
Yes.
Tell the panel about that.
I started in October, and then probably about, and I don't remember really the timeline. I would have to be looking at the calendar to actually tell you about the timeline. But we did have conversations when she, she would ask me, did you finish the order on, XYZ case? And I'm like, no. And after a couple of those interactions, she would say, okay, we need to sit down. We need to talk about the things that areas of deficiency or areas of improvement or areas of opportunity for me to improve. So we had, I was still learning. I had questions. She was always available for questions. But she also would say, hey, this is supposed to be done by this date. She would provide very specific deadlines if they weren't completed by the deadline, or she may ask me about it. Sometimes she wouldn't ask me, she was expecting me to come to her and say, okay, these things have been completed. These are the things that have been completed. And when I did not do that, then she would follow back up and say, okay, I asked you for this last week, and what's the status of it right now? So,
did you have any particular challenges in getting the things done that Judge Williams wanted you to get done or expected you to get done?
I did.
What were they?
I was just very overwhelmed. It was kind of like I had been practicing, 20 plus years at that point, 25 or so years at that point. And just the volume and the responsibility that singly fell on me was just more than I could handle at that point. So the challenge was, touching every email, responding to every phone call. Those were very challenging. You kind of think you're getting a groove and you think you're doing it, and then you're like, oh, you know what? I forgot I was supposed to do this. So I had a, to-do list and a checklist and a tickler system, but all of these were kind of self-created, not any type, again, a case management software. So, using Word, using Excel, using Outlook, those types of tools to try to keep up with what work was supposed to be done on whatever particular case.
Would
know,
you get calls from lawyers saying, where's my order?
I would get
Or
phone
emails?
phone calls and emails, yes.
And how would you generally deal with those?
Respond to give them a status, or, so let me just say this, in the family division of Fulton County, you may get a follow-up from an attorney on a case multiple times a month. And probably I would probably say the first few months that I was there, very overwhelmed with responding to the number of emails. So some of them did not get responded to. Some of them didn't get responded to. And that was not what was expected of me, but that was just kind of what the reality was at that point. Or if the status had not changed from the last time they emailed to say, hey, what's happening? Or I want to know what's happening. So what was supposed to have happened, if they emailed to ask about the status, they were supposed to get an email response with no later than, I would say, probably 48 hours to say what the status is. And if it was something that was needed from them, we would let them know they needed to submit something or bring something.
And you started in October of what year?
2021.
So have you reviewed the charges filed on Judge Williams?
I did look at those.
Were you there at any of the ones where she's charged with untimely response? I think you were there for most of them, right?
I don't recall the dates right now, but my tenure there was from October 2021 to June of 2023. So
You were, well, the ones I'm looking at, you were there, but do you have an explanation as to why it would take, according to the complaint, 10 months to file or 23 months to file, clearly over the 90 days?
it depends on the nature of the case. There were some cases that had been pending for a while before Judge Williams got there.
Right.
And they may have had a final hearing there were some final hearings or some hearings that were held even prior to my coming, right? But there were some that may have been held after. There were some cases I know that she spent time on just reviewing the evidence, reviewing her notes, trying to consolidate proposed orders that had been submitted from counsel, because sometimes the orders were like 60 pages or 80 pages, and that's because of the complexity of the case. So the more complex cases took a longer time.
And these were domestic cases?
Yes.
Have you practiced domestic law?
Ever in my life?
Yeah.
Yes.
So you understand the importance of somebody getting their child support or visitation, all that as quick as they can?
Oftentimes, there have been temporary orders on those cases.
Gotcha.
So the people were not operating without any direction from the court at all. So they weren't just in limbo. They were mostly looking for final.
Oh.
And yeah, I understand the importance of it, absolutely.
But do you have an explanation, though, from your perspective as to why somebody would say it's been X number of months, 10 months, please do something, and then it's another year or two before it's ruled on?
I do not.
Thank you.
Mm-hmm.
Did you have a process for knowing when an order was over 90 days old, outstanding?
We had a spreadsheet of outstanding orders, and so we would have the date, like the file date of the case, and the last hearing date. We also had, there were reports that could be generated from Odyssey. So Judge actually had us do one of the tasks that I was responsible for, and with the other members of the staff, was what Judge called walk the docket, which meant we had to basically take a look at every single case that was pending to determine what the status of it was, what needed to be done, how long it had been pending, there was a lot of emphasis on cases that had been pending for a long time. So she, even though those cases were there, it wasn't that we weren't aware of them or didn't have a notice about them, right? And it's not like you're not doing anything, but at the same time that you're doing, trying to make a decision about these other cases or getting to the final order of these other cases, you're getting 120 plus cases, new cases in every month. Like the assembly line did not stop.
Who
wheel
prepared
did
the
not stop.
spreadsheet you spoke of?
I did.
Did you bring any of those with you?
Did I bring the spreadsheets with me?
Right.
No. When I ended my employment with Judge Williams,
Right.
they remained there. It was, it's not my property, basically.
I understand.
Commissioner Hyde asked you about what you did when there were litigants who sent an email or call asking about the status of the cases. Do you recall that question and
I
your
do.
response there? Would you have conversations with the judge about litigant XYZ
Yes.
is pinging? Okay.
Yes.
What would those conversations be?
Miss Brown called it. Let me just give an example. Miss Brown called or Miss Brown emailed, and she's looking for her order.
Okay. And then what would be, in that example, what would be the judge's response?
Various responses depend on the case. I'm still working on it, may be a response. A response may be, Janelle, I asked you to, do a child support worksheet. Have you done that worksheet? She was aware, she was keenly aware of what cases she had, what was pending, what was outstanding. She knew cases by name, she knew them by fact pattern, she knew what was the last, order or ruling in the case. She may say, I gave them a pronouncement from the bench and they have a temporary order with blah, 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 blah. And so, yes, that order, the final order is not completed, but, we're working on it basically.
Would you then follow up with the litigants?
Sometimes if it were an appropriate communication. There were some times that I decided we gave them a status on this, 3 days ago, it hasn't changed, so I'm not going to respond to this one. Or, if you can imagine looking at 100 emails a day, and there's an art to it that you have to master. And, there was a time when Judge Williams came and sat at my seat, sat at my desk, sat at my computer and said, okay, let me show you how to do this. And went through the cases to say, this is how, to actually show me how to make it work, basically, right? So there's some cases, you scan the emails to look to see what's emergent, because there were some issues that, people asked for emergency hearings, or, it may have been something about custody or some safety with the child or something like that, if there were children involved. Or, someone may have safety or some safety issues. One of the litigants may have safety issues. So if we saw those, they was requests for emergency, we had to flag those, and those had to take priority. And then if there were cases that I had seen, like I've dealt with these individuals before, or, they would get basically put on a different, list in terms of response, if that makes sense. Some were urgent, some, okay, I can respond on these tomorrow, some I need to do this by, 5 p.m. today. These are matters that I need to follow up with judge about. These are matters that I need to follow up to see, actually what the status is. So just kind of balancing all of the communication in that regard.
Okay. Let me ask you this. From your perspective, was Judge Williams satisfied with your work performance?
She was yes and no. She always commended me for taking ownership for any deficiencies that I had, and letting her know if I had missed something or made an error, or, you know, taking responsibility for an error that I made. She was not pleased with the backlog of my work, that, you know, and the timeliness in which I was performing things or missing deadlines.
Did you receive any discipline with respect to your work performance or counseling from the judge?
Yes.
Tell the panel about that, please.
So Judge has communicated to me, and like we would have a meeting, or she may communicate in writing, and I'm just thinking of one time in particular. We had a meeting, and she basically had a list of areas for improvement or opportunities for improvement. And then we talked, she told me, you know, I need you to let me know by a date certain how you're going to respond to these, or how you're going to correct these.
Let me ask you about a specific document. Can we have just a couple minutes? Sure. Rather than have the panel wait while we talk amongst ourselves, I'll move on. Mr. Banks.
Okay.
Ms. Bowles, you started to talk about conversations that you had with the judge about your work performance, and the judge wasn't satisfied in some aspect with your performance, right?
Yes.
Okay.
Yes.
Did there come a point where HR for Fulton County became involved?
There was a time when HR became involved because I went to talk to them. I don't remember. I was never given I was not made aware of any HR involvement other than when I went to seek counsel from HR.
Okay. What did you seek counsel about?
I knew that there had to be clearly there had to be I say clearly, but I was going to HR to seek assistance in a case management software in some type of way that I could have some assistance in managing the case volume. And we talked a little bit about, just my disappointment, kind of in my performance, and just what ways I could do, what things I could take, or what steps I could take to try to improve upon those things.
Okay. Let's start with what you just said. What did you talk about with respect to disappointment in your performance?
Well, I've been practicing for 20 plus years, right? And I have been successfully maintaining a law practice. And most of my business was from word of mouth. I did not do a lot of advertisement, which was indicative of the quality of work that I did. And so in this scenario and in this environment, I wasn't thriving with the normal level of excellence that I was accustomed to professionally. And so it, after a while, began to, wear on me, but also just not wanting to disappoint Judge Williams, and not performing being the best performance, giving my best performance in the position, but also too, having a compassion for the people who were affected, the litigants who were affected, who may have, experienced some delays or.
Well, if you were, these are my words, struggling to sort of keep up and do the job, why didn't you just quit?
I couldn't afford to quit. Quitting was not, at that particular time, quitting was not an option, right? So I, unfortunately, am not independently wealthy. Had not at that point, still am not, still have to work every day. So yeah, that quitting was not an option. What I did do though was, because of, when I said to Judge Williams a couple of times, because termination came up at least probably 3 times, conversations about termination came up, in that if you don't improve in this regard, you could be facing termination, right? Or, you know, anyway, but my ask was, okay, let me take an opportunity to improve, and if I don't improve in these areas, or if I haven't figured out a way to make this better, then for the, you know, sake of the team, I'll bow out, basically.
So you and Judge Williams discussed a plan to improve your performance?
Yes.
Okay. Did it improve?
Yes.
When you eventually left Judge Williams, was it voluntarily?
It was. Excuse me. Okay, thank you.
You may, go ahead.
I am showing you a document that will be marked as, show you this document, National Security. I have a couple of copies, and I want to give one to the secretary. Hard copy.
Do you recognize this document, Ms. Bowles?
I do.
Can you tell the panel what it is?
It was a work plan that I created to ensure Judge Williams that I was working on what had gotten behind and what my plans were going forward.
Who authored the document?
Who did what?
Who
Who
wrote it?
authored?
Mhm.
I did.
Okay. Do you have any? We want to move to admit this document into evidence as Respondents Exhibit 5.
All right, any objection?
No, Your Honor.
Submitted?
Thank you. So can you describe to the panel, Ms. Bowles, the types of job duties you were being asked to improve upon?
So emails was the primary way that people communicated with chambers. So they would email either asking for request for a hearing, request for status, and if the emails were backlogged or not responded to, or if I hadn't read them, I wouldn't know what was happening. So in order for us to move forward effectively, I needed to have a plan for checking and addressing the emails. And a little bit what I mentioned before, and being able to kind of triage them appropriately if they were emergent, you know, if they needed to be responded to or could be responded to in, 2 or 3 days, as opposed to, by close of business, depending on what the ask was or the request and what needed to be done, what action needed to be taken. So emails was one area. Orders was another area. And that was the outstanding orders list that I mentioned in the memo. And that was, again, one of the spreadsheets that
I created.
I saw there, you gave some testimony earlier about walking the docket.
Yes,
Does walking the docket appear there?
it is.
Okay.
Um,
What was the issue and what was the potential fix that was discussed?
So the walk in the docket just needed to be done on a monthly basis. I think we had done it, at this point, we may have done it a couple of months, but had not done it on a consistent monthly basis to provide an update. And again, it was another way to know what was pending, to know what cases needed to be addressed, sooner, and just kind of know, if it was something that the JO needed to handle, if it was something that we needed from the litigants, or if it was something that was missing from me.
Were there any other major aspects of your job included in that memo where there were opportunities for improvement and a plan to go moving forward?
Calendaring, just the calendar audit. So after, we would have status calendars, motion calendars, any type of matter that was held, Judge Williams would make notes on her calendar, and the notes indicated what next action needed to be taken, if any. And so we were to audit as a team to see if what was the next action. Did it need to be scheduled for a final? Did it need to be scheduled for another status? Did a motion hearing need to be scheduled? And then also another aspect was jury trial. So every case was not a jury trial, every case would not request to be decided by a jury, but those that were, we needed to identify which cases those were, what the demand, what the request was, how many days, so that we could properly schedule. Judge Williams had her calendar scheduled for an entire year, so she would have already told me jury trials can be held on this week, or it may be something with when it began post-COVID, when we actually had the jurors coming back in person. There was a calendaring system or jury system, scheduling system that each judge would have based on what the county set up.
Okay.
What's a LOA?
Leave of absence. If you need more, or that's
No, I got it.
all right.
Any other major aspects of your job discussed in the memo?
Communication, monthly reports, hearings, task lists, walking the docket, and on court days to ensure that everything ran smoothly for me to be in place in my office by a certain time.
What was the problem in that regard?
My timeliness in arriving to the office became an issue, or was an issue, a couple times. I mean, maybe more than two, maybe pretty regularly. I don't remember the consistency. So one question you asked earlier was what made me seek the position.
Yes.
I became, while in private practice, I became primary caregiver for both my parents. My sister and I shared in that responsibility. And as my parents got older and needed more assistance, maintaining my law practice became a little bit more overwhelming. And so I sought employment so that, I no longer had to be the boss. I no longer had to call all the shots at work. And then my sister and I shared those at home. So there were, and also transitioning from being self-employed for 20 plus years and then navigating through balancing maybe multiple courtrooms, multiple court appearances. The court calendar starts at 9, but the judge might not take the bench until 9:20. And so as long as you're there as counsel to make a report or report to the courtroom deputy by 9, or you call ahead, and, so there were a lot of built-in aids
available to you as a solo practitioner from a court perspective. In this position, I was the court. So if the court, like, there's nobody for me to call to say, hey, I'll, call ahead, basically, to say I'm on the way. We did have, we were a great team and we supported one another, but Judge Williams, is very timely. She was very adamant about things starting on time, her court starting on time, so the whole notion of me getting there after her was not gonna fly.
Okay.
So that's why that came up.
All right. Was there any follow-up after this memo? Any check-ins?
Yes. I mean, one of the things what I did ask from her was to have a weekly meeting just so that we could check on status, to see kind of where we are along the way.
And did things improve?
I believe things did improve, but we did get better. Our team got better in kind of working. There were still things that needed to be done. There are still things that may have remained outstanding, but there was improvement.
Okay. Let me back up and ask, you said you went to HR and you spoke to HR about the disappointment in your own performance. Who did you speak with?
Heather, I don't remember her last name.
Okay. And the first part of your response was that you asked for case management support and software. Did you get any assistance from HR?
She told me what they used internally as a system, like a software that they use, a cloud-based online software that they use, but it was not something that had been adopted countywide. She did offer that she could have IT come to speak with me to see how maybe Odyssey could be used in a different capacity. When we would generate the reports, the monthly reports what we use for walking the docket, there were certain fields that had to be completed, but they weren't printing out on the report. So we did have conversation. I did have multiple conversations with IT even before talking to Heather about that, to just see how can we modify this, how can this report, how can this software be more user-friendly for us as a staff.
Okay. I heard one of the commissioners ask you about your separation, and I believe you said you resigned.
I did.
Okay. Did you resign in lieu of termination?
I think I'm gonna say yes, because that kind of was it wasn't really a handshake deal, but it kind of it got to the point of, if this isn't getting better, then Judge allowed me an opportunity to step aside. But I was experiencing some family medical and personal medical issues, and prior to my termination, I took FMLA, or I had to take FMLA, and so I discussed with Judge about not returning. At the end of the FMLA period, I could have returned because I was on a intermittent FMLA approval at that point. But yeah, we basically discussed that it was better for me not to return.
Okay.
But she did not terminate me.
You officially resigned?
I did resign.
Okay. Based on your personal observations and work with Judge Williams, would you describe her as a good judge?
Excellent judge.
How so?
She learned very quickly. She remembered facts. She remembered case law. She remembered code sections, which was always would tell her there was a substantial age difference. And I would always remind her that of my age and how old I was when she hired me, because I was like, you're running circles around me with your brain, and so hey, I just want to let you know that I'm a little older than you are, and so, yeah. But I joke with her about that, but very seriously, she was a judge of integrity, compassion. She cared. She didn't rubber stamp orders. You know, there were other instances where I could see that, you know, a lot of thought may not have gone into a ruling. And that was for me being in private practice, having been a practitioner, you know, just knowing that I don't even really know if this has really been considered. You know, but Judge Williams took time. She was involved in the community, so she didn't just come to work and go home, right? She was involved with making sure that other attorneys, other lawyers, you know, she shared her knowledge with, you know, through CLE's involvement with different bar associations. She spent a lot of time continuing her learning. So those were all things that were very impressive to me, not just because I was on her staff, but because of my, you know, having been in practice for so long and having been before several judges, just knowing that she was doing a dynamic work.
Okay. All right, I am going to switch gears. I don't know if the panel has any, I'm going into a different topic, and I know we're nearing lunch. I want to check in with you to see if we're doing anything
You guys
different.
want to stop now, or do you want to keep going with this witness? Okay, we'll go ahead and stop then, if you're going to go into a different area. So why don't we pause there? We'll break for lunch for an hour and 15 minutes, and we'll come back at 2:15.
Okay, thank you.
Okay, thank you.
Welcome back, Ms. Bowles.
Thank you.
I want to switch gears and ask you about your interactions with the JQC investigative panel, in particular the director's office. First, have you had conversations with anyone from Director Beal's office about the charges against Judge Williams?
Yes.
How many times have you spoken with someone?
Maybe 5.
5 conversations with the director's office?
So if I can count them out, the investigator twice. Maybe 4. Lynn, maybe once. And then Courtney, I think once by Zoom.
You mentioned Lynn. Who is Lynn?
She's a staff member, I assume, with JQC.
Okay.
She notified me about scheduling and the like.
Okay. Was that the very first conversation you had with someone from Director Beal's office?
The first conversation was the investigator. I believe his name is Jonathan.
That was the first conversation?
Yes.
Okay, and then there was another conversation with Lynn and another conversation with Director Beal?
Yes.
Was there
2
4?
touch points with Jonathan because I followed up with him. And then a touch point with Lynn and then with Courtney.
Okay. When you say Courtney, you mean Courtney Beal, the director?
Courtneyville, yes.
Okay. So the first conversation that you just mentioned with the investigator, when was that?
Sometime maybe May 15th or 16th, around that time frame, 2025.
Okay, just before the first phase of the hearing?
Yes.
Prior to May 15th-ish, 2025, was anyone from the JQC's investigative panel or the director's office in particular in touch with you?
No.
Do you know if anybody attempted to reach you before May of 2025? Anybody from the JQC?
I have no knowledge of any attempts prior to that time frame.
Do you know whether anyone from the JQC investigative panel or the director's office had your contact information?
Yes, I do believe they had it.
How do you know?
I was still employed when the investigation started, and Judge Williams notified me that she gave them my contact information.
Around when was that?
2022. I don't remember the month, but I think early 2022, middle 2022, somewhere along that time frame.
So early, middle 2022, Judge Williams told you that she had given your contact information to
She
who
said
in
the
particular?
JQC investigative panel
Okay.
or team. I don't remember the exact division, but she did say JQC.
What was the context?
She indicated to me that she'd been contacted about a pending investigation, or not a pending investigation, a complaint had been filed, and she then told me that was, she gave my contact information. Part of the communication with Judge was about the particular complaint or the nature of the complaint or the subject matter of the complaint, I guess, because it was involving one of the cases that was pending or had been pending before her.
All right, I'll ask you some specific questions about that. So no one from the JQC contacted you in or around February, March 2022?
No.
Do you know if no one from the JQC contacted you before the formal charges were filed? Do you know?
No one contacted me until May of 2025. So if the charges were filed, I assume the charges were filed before that, sometime in 2022, I think, maybe. I'm not sure the exact date of the filing.
Okay.
But yes, I was not contacted prior to that,
2025 timeframe.
All right, the first conversation that you had with the investigator, was it substantive?
No. Well, not detailed, but I did have questions. I mean, so it depends. Substantive depends, right?
Okay, did you have conversations with the investigator about the allegations in the formal charges?
No.
When's the first time you had some contact with someone from the JQC's office about the allegations in the formal charges?
A couple of days later, maybe, 3 or 4 days later.
Okay.
I had a Zoom call with the director and investigator and a staff attorney.
Okay. Ms. Stone?
Yes. Is that Ms. Stone? Yes.
How did that conversation come about?
The investigator contacted me and said that Director Ville wanted to speak with me, and the first time I spoke with Jonathan, he said, I need to know how to subpoena you, or how to get the subpoena to you. We need to subpoena you to be a witness. And I was like, whoa, okay, sure. And I said, well, he said, how can I get it to you? And I said, can you email it to me? And he said, yes, as long as you acknowledge receipt of the email. And I said, that'd be fine to email it. And then he said, someone from our office will be in contact with you about scheduling, because I believe the director wants to talk to you before the hearing.
Okay. So you voluntarily accepted a subpoena?
I did.
And then did you speak with the JQC voluntarily later?
I did.
When you had the Zoom call that you described with the three people from the JQC, not the hearing panel, but the three people on the call, how long did that call last?
About 90 minutes.
Did you limit the call in any way?
I did not.
If someone from the JQC had reached out to you, say in May 2024, a year before, would you have voluntarily spoken with them?
Yes.
I understand that you accepted a subpoena from the JQC. At some point, were you released from that subpoena?
Yes.
When was that? Ish.
Right. A couple days after, so May 20-something, 24, 25 maybe, around in that time.
Do you know why?
I do not know why.
Now, the allegations in the formal charges against Judge Williams, have you reviewed the formal charges?
I reviewed some of it, yes.
When did you first review the formal charges?
I think it was around the May timeframe when I was contacted.
May of this year
Yes.
is when you first reviewed the charges?
Yes. The formal charges?
Yes,
Yes,
the
yes.
complaint against
Yes,
Judge
yes,
Williams.
yes.
And what was your reaction to the charges, to reviewing the charges?
Well, I was concerned was one reaction, appalled, surprised, shocked were some other reactions that I experienced, because the details of what were included were not true based on my recollection. And it appeared that I was an integral part of the story, since I had been listed by my by mention of my name, or by mention of my title, and then my initials. And then I, was confused about how charges could have been, a formal charge or whatever could have been filed if an investigation were supposed to happen. So prior to this, I didn't have any I didn't have a detailed knowledge about how the JQC process worked. And when I was contacted, I went to their website and just kind of did some kind of perusing around. Didn't read a lot of information, but I did find the formal charges there, or I guess it's formal charges. But at one place I saw where there was an investigation, or the process said that a complaint could be filed, and then there would be an investigation process. And after the investigation, they would determine if formal charges were to be filed. And so I was shocked, confused, surprised that it had gotten to the final stage and I had not been contacted. Like, nobody called me to say, hey, did this happen? Did somebody talk to you? Because, clearly I was an integral part of the story, so why not talk to me?
Okay. Let me ask you about some of the specific allegations in the formal charges. May I approach?
You may.
Which set of charges, Ms.
The first step, 2024.
You testified, Ms. Bowles, that some of what you read in the formal charges wasn't true, right?
Yes.
Okay. For expediency, let me just, if it's all right with the hearing panel, let me just direct your attention to page 3 that discusses complaint number 2022-102. Paragraph 7. And I'll tell you, Ms. Bowes, this is the complaint about, based on Brandy Alexander's allegations against Judge Williams. In paragraph 7, there are some references to initials and some references to Judge Williams' new staff attorney. You see that?
I do.
Okay. Did you understand JB, Judge Williams' new staff attorney, to be you?
I did.
Okay.
Because I started on October 18th, 2021, and my initials are JB, and I was Judge Williams' new staff attorney on October 21st, 2021. So that part is true.
Okay. Is there something there that is not true in paragraph 7?
My speaking with Catherine Franklin.
So you did not speak with Catherine Franklin?
I did not.
Now, that was a long time ago. It was in 2021. How are you sure that you didn't speak to Catherine Franklin?
Just about the way October 18th, 2021 was my first day.
Mm-hmm.
At that time, we had staff in place, so I had not been given a direction to answer the phone. And then the communication to Judge Williams about Brandy Alexander contacting the office or being a subject of a call to the office, the message.
I'll walk you through some of that.
Okay.
Beyond paragraph 7.
Okay, I'm fine.
When you spoke with Director Veal in May, did you tell her that it wasn't true that you had spoken with Catherine Franklin?
I did.
I
did, yes.
You told her it was not true?
Yes.
Okay.
Well, did you say, though, didn't happen on October 18th, 2021? Because that's what I heard you say.
I said, she asked me how did I know it wasn't true. I said, because on October 18th, 2021, that was my first day, and I was not answering the phone.
But she put this lawyer speak in there on or about, so it could have been a little before, a little after, couldn't it? I don't know what on or about means. I've always wondered that myself.
That is a good question. And what are you asking me?
So you just
Did it
don't
happen?
remember it on the 18th? Could it have been the 19th or the 20th or the 25th or something?
I don't know.
Well,
So, okay.
Commissioner Hyde's asked, go ahead.
Sorry, I was just saying, is it possible, do you recall having a conversation with Catherine Franklin at any point about Brandy Alexander?
I don't recall that, no.
You don't recall it, or it didn't happen?
He asked, did I recall it? I said, I don't recall it.
And I'm saying you don't recall, or it didn't happen. Which one?
I may have spoken to her about something on the case, but I can't say that I never talked to Catherine Franklin about Brandy Alexander's case.
Okay.
I guess our confusion comes from you were so adamant a minute ago about this never happened. Is it now a possibility that at least the conversation did happen, just not on the date that it states?
I'm going to say no.
It's not a possibility that it
It's
happened?
not a possibility.
Let me ask it this way. Did you talk with Catherine Franklin about an assignment to a senior judge on for Miss Alexander's case? Did you ever have that conversation?
I don't recall having the conversation. No.
Right. Then
So you're
our confusion is
confused.
back.
Yes.
Yeah, mine too.
Our confusion is back. You don't recall it happening. Does that mean there's no possibility that it did happen?
I'm not sure what the disconnect is. Maybe the disconnect is in my mind in terms of what everybody else is unclear about. I did not talk to Catherine Franklin about a process for a senior judge.
Okay. When Ms. McFadden asked you, you said you don't recall doing that. And so when a witness says, I don't recall, in my mind, that leaves the possibility open that it did happen, you just don't remember it happening. Is that fair?
Don't recall generally does lend into that interpretation. Yes.
But would you really expect to remember you said you got how many emails a day and how many phone calls?
Correct. Correct.
So could it be that the witness's memory, who probably didn't have that workload that you have, might have a better memory than you do? How would you I don't remember what I had for lunch.
Today or another day?
On the 18th.
Oh, I see. So let's start over. On October 18th, 2021, do I remember talking to Catherine Franklin about Judge Williams, about having a process to get a senior judge?
No, that's not my question.
Okay.
On or about October 18th, even if it's not the exact date about October 18th, somewhere in October, did you have a conversation with Catherine Franklin about a senior judge for Miss Alexander's case?
No.
November, December, did you have a conversation?
No.
Okay. Let me ask you then. Are you now changing your answer from I don't recall to a definitive no?
I am changing it to a definitive no.
And that's based on your memory?
Yes.
Why'd you say I don't recall previously?
I'm an attorney, and I generally answer in a gray area.
Okay. Okay. I appreciate it. Thanks.
Should I wait for you to ask me a question?
What other answers have you given us today that were in the gray area?
None to this point.
Okay. Will you let us know if there's answers in the gray area from here on out?
I'll do the very best I can.
Thank you.
You're welcome.
Okay. So paragraph 8. Let me ask it this way. Did you give a message to Judge Williams about someone requesting something about a senior judge? Did you give a message to Judge Williams about a senior judge pertaining to Brandy Alexander?
No.
Do you know who did?
Well, do you know if it happened at all?
So I do believe that it did happen, and I believe that it was one of the other staff members in the office.
But you're sure it wasn't you?
I'm sure it was not me.
How do you,
How?
tell the hearing panel what you know about a message being given to Judge Williams by someone in her office about Brandy Alexander pertaining to a senior judge.
So I remember Judge having a piece of paper that had Brandy's name on it, and she asking us, what is this about? And Judge said, oh, she's a guardian ad litem, I'll contact her.
Did the piece of paper not mention Miss Franklin's name? Because that's who called. So
That's the allegation, yeah.
I didn't see the paper. Judge had, well, actually, I did see the paper because Judge actually gave it to me later to say, you know, these are some follow-up tasks or follow-up items I need you to do. But on the piece of paper that Judge gave me, it only had Brandy Alexander's name on it. I did not see Catherine Franklin's name on it.
Okay. And what happened next?
Judge called Brandy, and they had a conversation.
Let me ask you some specific questions.
Okay.
Did you hear the conversation?
I only heard what Judge Williams was saying.
Was it on speakerphone?
It was not on speaker.
Okay. Did you hear the start of the conversation?
No.
Where were you relative to where Judge Williams was when Judge Williams was on the phone?
I was sitting at the desk in my office. My office is adjacent to Judge Williams or next to Judge Williams' office. We have had a shared wall, and my door opened into the hallway. That Judge walked through that hallway to get to her office. She was standing by her office door part of the conversation, and she walked to the front. She was still in kind of ear range for me in my office because she was outside of my office door in the hallway.
Okay. Could you hear when the conversation started, even if Judge Williams wasn't standing in front of you at the time?
I may have heard her. I don't know if I heard for, like to say, oh, she said, what she was actually saying. I started to listen because she said, okay, she started to give what I believe were going to be my instructions. So I started to listen.
Okay.
I heard part of what she was saying.
What is the first thing you heard?
We can get that moved to a different calendar, take you off the general status calendar.
What did you understand that to mean, if anything?
Well, later understood it to mean that the cases start on the judicial officer track. The case was on the judicial officer track with the initial time. The 30-day status is usually a large calendar. So I later understood that she wanted that case to be removed from the larger status calendar and then to be not on the JO track, but to be heard by a judge.
Do you know why?
She indicated, I know what Judge did say, yes.
What did she say?
She indicated that Brandy was a guardian ad litem. She had a lot of cases pending in front of her that she had been assigned, and maybe other litigants and other attorneys who may also be on those status calls could hear. When you have a status, it's just open calendaring, basically. So there are multiple parties that are there. So they would hear the nature of her case or know that she had a case, and she did not want that to adversely affect her professionally as a gall and her influence on the cases.
During your time with Judge Williams as a staff attorney, had you seen her do that in other cases, move matters from the mass JO calendar?
Yes.
And give us some examples of when that has been done in the past.
There were some cases where allegations were involving some type of
abuse with children, or there were cases where the high-profile litigants, some government officials, some athletes, some TV personalities, entertainers, and because we were using Zoom primarily, the status hearings were not in person. There was no way really to police or limit what people were doing, and so if there were some issue regarding, if judge felt in her discretion that there was an issue that needed to not be publicly spread or whatever, she wanted to put it on a separate calendar.
Ms. Bowles, at some point during that conversation that you overheard, did it become apparent to you that whatever they were discussing had nothing to do with Ms. Alexander being a guardian ad litem and more to do with an active case that was pending before Judge Williams?
No,
That did not become apparent to you?
not, oh, yes, it did, because
They were
it
talking
wasn't her guardian case, it was her personal case.
Right.
Judge did determine that it was her personal case.
And Judge Williams continued to have that conversation after she determined that this was not about guardian ad litem work, but an active piece of litigation that was before her, and this was the litigant in that litigation.
I'm not sure how much more of the conversation, but it was basically, we're going to change this calendar, or change the date of your hearing, change the date and the track of the case.
Did you ever see Judge Williams have other ex parte communications with litigants in the open cases that she was presiding over?
No.
Okay. This is the only time?
Yeah, and I guess I wouldn't have considered it, I guess it would have been ex parte, but when I think about ex parte communication, if it's something regarding the substance of the case as opposed to like procedure, but also Judge immediately gave me direction when she said, when she realized what was happening, she gave me direction about what next steps to take.
Did you hear Judge Williams during the conversation talk about anything substantive pertaining to Ms. Alexander's matter?
I did not.
About how long did the conversation last?
Maybe 10 minutes. It was a short conversation.
Did you hear the end of the conversation?
I don't remember if I heard the end, because Judge, I do remember it was a short conversation because Judge was on break between matters. Like she actually had a case pending in the courtroom that she had to get back to.
Okay. Let me ask you about paragraph 10 of the charges in front of you. Did you hear Judge Williams say during the call that a senior judge would not be assigned to hear Brandy Alexander's case?
No.
Did you hear Judge Williams inquire about whether Miss Alexander was embarrassed to have Judge Williams hear her case?
No.
Did you hear Judge Williams mention that she and Miss Alexander were members of the same sorority?
No.
Any mention of sorors by Judge Williams?
No.
Is that something that would have stood out to you if you had heard it?
It definitely would have, because Judge Williams and I are members of the same sorority. So if I had heard her mention that, I would have said, it would have spiked or piqued my, that definitely would have been something that would have stuck out.
If she had said that, would that be appropriate or inappropriate in your mind?
If she had said to Brandy that she
What
was
she's
in the
charged
same-
with saying, yeah.
it would not be appropriate for her to say we're members of the same sorority.
Have you heard Judge Williams speak to litigants during your time with Judge Williams? Have you heard her speak to litigants about being in the same sorority as she
No,
is? Using the term soror and referring to people who had matters pending before her?
no.
Okay. Paragraph 11. Did you hear, well, tell me when you've had opportunity to review it.
Okay, I've read it.
A couple of questions here. Did you hear Judge Williams tell Ms. Alexander that you, Ms. Bowles, had expressed concern that the call with Ms. Alexander would be an ex parte communication?
No,
Did you ever separately tell the judge, hey, don't call Ms. Alexander because it would be an ex parte conversation?
no,
Anything like that?
no.
Is it your understanding that all ex parte conversations would be inappropriate?
The only time I think ex parte communication would be appropriate is if there's a question about procedure that needs to be answered, like what time is a hearing, or you know, something to that regard.
Did you draw up any type of notification to the other side that wasn't on the ex parte that this ex parte conversation happened and here's the substance of the conversation?
I did not.
In your whole time being a law clerk, you did not?
Oh, did I ever do it, generally speaking?
Yes, ma'am.
Yes. Yes. In this particular case, I did not.
Thank you.
Let me continue with paragraph 11. Did you hear Judge Williams tell Ms. Alexander that she told you that making the call to Ms. Alexander was fine because Ms. Alexander was a soror?
No,
What about it's on the shield?
no,
Did you hear Judge Williams at any point in the conversation say anything about the shield?
I've never heard Judge Williams say anything about the shield.
Okay.
Not then, not ever.
You started out your testimony about the allegations in the charges that things were not true. Is this one of the things that was not true?
Yes.
Okay. What else stood out to you about not being true?
That I told Judge that she shouldn't make a phone call because it was ex parte communication. That is not true.
Is that something that you would have told Judge Williams?
Quite honestly, I don't think that would have been necessary for me to tell Judge Williams. She has the knowledge and ability and understanding to know. But if there were some, egregious action or concern that I had, and in my capacity as a member of the bar, would I try to warn another member of the bar or my judge from doing something? Sure, but it wouldn't have been necessary. I don't think it would be necessary. Yeah, and it was interesting that, so it says, judge told respondent that I expressed concern and that it would be ex parte communication. That's untrue.
Did anybody ever ask you, anybody from the JQC ever ask you if it was true?
I believe they did
When?
during the Zoom call in the May 2025 timeframe.
And what did you say?
It was not true. And the SOAR is on the shield. Those are not typical words that are just kind of thrown around. And especially not in this capacity, in a professional capacity. This kind of more of a collegiate type of colloquialism.
Okay.
And Judge Williams, although she and I are members of the same sorority, it was not, I mean, it was, she does not lead with that. She doesn't present, like she, you know, it was very rarely did we engage in that type of conversation to say soror or on the shield or sorority.
Okay. Did you hear Judge Williams, I'm moving on to paragraph 13. Did you hear Judge Williams at any point in the call ask Ms. Alexander if she wished to have her attorney KF on a three-way call?
No.
Anything about telling the lawyer about the plan?
No, that I heard Judge Williams tell to Ms. Alexander, no.
Okay.
But the call happened, just no word on the plan. Is that what your memory is?
The call did happen, yes.
Okay.
No memory of the plan, correct.
Commissioner Hyde started to ask you, I think it was Commissioner Hyde, about notifying the parties about the conversation with Judge Williams, and you said there were some instructions given to you. So I want to take you to after the call, and you mentioned the instructions. What instructions did Judge Williams give you with respect to Ms. Alexander?
Judge said to reset their hearing from the JQC's status calendar and schedule the hearing before her, put it on her track, her case track, basically. And then I was to email the parties and notify them that she had spoken with Brandy and that she was removing the matter from the JO's tract and putting it on the track, and for Judge Williams to hear the cases.
Did she tell you to do that on the same day that the call with Ms. Alexander occurred?
Yes.
So for Judge Williams' instructions to you about removing the matter from the calendar and rescheduling it, did you do that?
I did not.
Why not?
I put it on my list of things to do, and it did not get done at that time.
Okay. With respect to Judge Williams' instruction to you to let the parties know about her conversation with Brandy Alexander, did you do that?
No.
Why not?
It was all part of the same task that was on the list of things to do.
At some point, did Judge Williams learn that you had not moved the case and spoken with the parties about your conversation with Ms. Alexander?
Yes.
How?
There was, I think the parties reached out to, or one party reached out because they filed a request for a temporary hearing, and they inquired about like login information, and the Will Williams, who's the case manager who's over the JO's tract, directed them to me because there had been a conversation that this needs to be on Judge Williams' calendar. So typically if there was a case, either if the parties had filed a Rule 1004 or if it was something that judge became aware of that may be a sensitive nature, we would communicate between the case manager and between myself, also maybe the judicial assistant involved, to say this case is going to be moved from this track, so any pending hearings, they're going to be removed or canceled. So that would have been, but judge typically didn't follow up to say, as soon as she gave a task, to follow up and say, did you do it, did you do it, did you do it? So she would learn about it if the parties made some communication to her.
Okay, so Judge Williams had not followed up with you to say,
hey, I asked you to call to inform the parties, did you do it?
Correct.
Is that something that Judge Williams would have normally done?
To follow up to say, did you do it?
Yeah.
Not initially, no.
Okay. Suppose I'm going to hand you a document and ask you to take a look at it. Judge Burleson, this exhibit has previously been admitted as P2.
P2. Okay, got it. Thank you.
Ms. Bowles, you recognize this document?
Yes, it's an email. Internal email.
I want to
Well-
ask you first about the email that is dated October 28th, 2021 from Will Williams.
Okay.
Okay. And for expediency, I'll summarize it, but tell me if I'm getting something wrong. Mr. Williams says, per Janelle Bowles, newest staff attorney, that the hearings on this case, this is the Carey versus Alexander case, is that Brandy Alexander's case?
It is.
That the hearings on this case would be heard by Her Honor. And then that you will respond to them, to the parties in this case.
Yes.
Okay. So this is October 28th, is about 10 days after you started and the conversation with Ms. Alexander occurred.
Yes.
Is this what you meant? Is this how the parties learned that the matter had not been moved?
Yes. And I don't know if Judge Williams even knew at this point that it had not been moved, because I think she may not have been aware about my not. I know that there was an issue when the parties appeared about what happened and why, because they had questions about why was this reset.
I'll ask you about that, but let me ask you one more question about this document. At the top there, looks like this document is coming from you to Judge Williams on Monday, February 14th, 2022. Do you see that?
Yes.
Do you know why you would have been forwarding an email chain from October 28th, 2021 to Judge Williams in February of the following year?
Judge asked me to forward her any communication about the Carey versus Alexander case, any emails that I would have received.
Do you know why?
Because of the JQC charge.
The JQC complaint?
Complaint.
Okay. Had you forwarded this document to Judge Williams before that time?
No.
You started to mention, Ms. Bowles, in your testimony that at some point later the parties had questions. Will you tell the hearing panel what you know about that?
So ultimately, I did reschedule the hearing, and the parties appeared, and they wanted to know why it had been changed, why the date had changed, and so we scheduled the temporary hearing, and I believe it was their initial status hearing at that time, because they had not had the initial status hearing that would have been before the judicial officer. And Judge Williams explained to the parties that she did give direction to her staff to communicate to everyone. So she learned at that time that it had not happened.
Did she say anything to you about it, that the fact that it had not happened before the parties showed up?
Yes.
What was that conversation?
Just about, this is an example of when she gives a direction of how
she gives direction. She's very methodical. Follow her instruction or direction, and this is an example of what could happen if you don't follow or you don't do it timely.
Okay. Was there anything else in the formal charges that stood out to you as not being true?
As far as my knowledge, I've read through like up to paragraph 30, 31. I don't see anything else that's untrue to that point.
Okay. I'm not searching for anything in particular. I just wondered if anything else stood out to you. Is there anything else that you'd like to share with the members of the hearing panel at this time?
Nothing other than I'm not sure why my name would be listed and I wouldn't be contacted, but I think I've already been expressed.
Okay. I have nothing more for you at this time.
Thank you.
Thank you.
All right. Ms. Field?
Thank you, Your Honor. Ms. Bowles, we've spoken so you understand my role in this process and the fact that I'm prosecuting this matter on behalf of the investigative panel of the JQC, correct?
Yes.
Okay. I want to start off, I'm just going to kind of track your direct examination testimony, but you characterize getting into your position with Judge Williams as a staff attorney as kind of jumping in and being overwhelmed at the volume of work, correct?
Yes.
Who did you interview with for that position?
Judge Williams.
Okay. Was it not explained to you during the course of your interview what the volume would look like for you as her staff attorney?
I don't recall she did say it was fast-paced, that it was a lot of cases. She did talk about volume. Yes, it was explained.
Okay.
What I was going to say was I don't recall her saying we have 650 cases pending. But yes, she did talk about volume, fast-paced movement. Yes.
Okay. Did she make clear to you during the interview what her expectations of you would be as her staff attorney?
Yes.
Okay. Tell me about your onboarding process, not through the county, but with her office. Did you receive assistance or guidance from the former staff attorney, Ms. Bush?
Yes.
Okay. And what did that consist of?
I shadowed her for a period. I actually hadn't officially started, but I volunteered to go in to shadow her. I did some shadowing by Zoom with her for some of the hearings, and participated in some, I guess maybe status or staff meeting kind of status with Ms. Bush, Judge Williams. And she had a manual that she provided, and she also provided like templates, and she made herself available in terms of her contact information if I needed to follow up if I had any questions.
Do you recall, as part of the manual or any of the materials that Ms. Bush left for you, there being a PDF list of all of the cases that were pending before Judge Williams?
Yes, I think they were, it was in the form of not all the cases pending, but cases that had outstanding orders.
Okay, so when you started, you would have had the list that was created by Ms. Bush, and you recall that it just had outstanding order cases on it, correct?
Yes.
Okay. Is that, keeping that list to keep track of the cases that had outstanding orders, is that not something that you continued to do?
Yes, but I didn't use that same list.
Okay, so you started to utilize the spreadsheets that you testified about earlier?
Yes.
Okay. And on those spreadsheets, were you tracking the cases that had outstanding orders?
Yes.
And you testified that you created those spreadsheets. Approximately how long had you been Judge Williams' staff attorney when you created the spreadsheet?
Maybe 6 months.
And was that spreadsheet something that was shared with Judge Williams?
Yes.
In addition to the spreadsheet that you created, you also received monthly reports from court administration regarding Judge Williams' caseload, correct?
We did receive emails from court administration, yes.
Okay. And did you utilize or did you use that information? Did you build that into your spreadsheets?
We used that to monitor the cases, or what I referenced earlier, walk the docket. And yes, they would be then, depending on what the status was or what category, it would go on the appropriate spreadsheet, yes.
And just to be clear, when you use the term walk the docket, that was a meeting with Judge Williams and her staff about the cases on her docket?
Part of that process did include a meeting, but no, the walking the docket was actually us manually reviewing the cases. So it might be I'm gonna just say 60-page report, and we would split the pages. So each member of the staff would have 20 pages. And then we had a deadline by which to have a status, provide that back to Judge Williams. And we may meet during that process to talk about the status. But each person had, 20 pages of cases. So the spreadsheets were open, available to all the staff to add to the appropriate spreadsheet, depending on what the status was.
Did the spreadsheet show orders that were outstanding?
There was an outstanding order spreadsheet, yes.
And you got that every month? Or
So the one that I created, we updated it.
so you made it?
The outstanding order spreadsheet is something I created, yes.
And you did that for your organization or to help Judge Williams not have orders that were languishing, for lack of a better word? You were trying to help her?
I did it for my organization, and then office status, just the overall efficiency. Having a list of a spreadsheet list to keep us apprised of what orders needed to be completed was helpful, so we would know what was outstanding, but you still had to have the man hours or labor hours to complete it, right? So
Did you do anything different with the cases that indicated they were over 90 days old, waiting on an order?
I don't know that there would have been any, we had the same process, depending on whether it was 30 days or 90 days, except to just make sure that there wasn't something that was outstanding, but we did that with every case.
Are you are aware that there's a mandate that the judge rules in 90 days generally? Is that your recollection?
I don't know that I had that understanding at that time. I understand that that is a rule, but I don't know how much that's enforced across the board.
Thank you.
But were you told during your employment with Judge Williams, hey, there is a statute in the state of Georgia that says that I have to rule within 90 days on motions? Were you told that?
No.
How often did you update that outstanding order spreadsheet?
Maybe bi-weekly. It would be updated if we filed and completed orders also. So it could be daily, it could be, but generally bi-weekly.
We've heard testimony that Judge Williams prepared some orders on her own. And I also understand that she would have her staff attorney, whichever one it was at the time, also prepare orders. How, during your time as her staff attorney, how were the two of you dividing up the responsibility for drafting and preparing orders?
The orders that were more complex, that had more substance, or that, were, I'll just say, more complex, Judge Williams typically will handle those. If there were, pretty straightforward family matter, it would be something that I would handle.
And you testified on direct that you got behind in drafting and preparing the orders that were yours to prepare, correct?
Yes.
You also testified that Judge Williams told you that in circumstances where she had not asked the parties to prepare and submit proposed orders, that was something that you could do, correct?
Yes.
Did you ever do that? At any of these points where, you had gotten behind, did you ever go through and say, oh, well, I'll reach out to the parties in this case and ask them to send a proposed order?
Yes.
Okay. How many times do you remember doing that?
Maybe 10 times.
Seems as if it was pretty common that the parties in these matters would prepare and present proposed orders to Judge Williams' chambers. Is that accurate?
Yes.
Okay.
So sometimes when I was reaching out, the parties may say, oh, I emailed the proposed order to the former staff attorney's email, or they had spelled my name wrong and I didn't get it. So sometimes it would be a resubmission from their part, but just correcting an error. They may have sent it to the wrong place, or sometimes they would send it to Judge Edwards' staff attorney, who was the judge that took, who was there before, who had the family law docket before Judge Williams.
If you had to assign a percentage to the number of matters where Judge Williams asked the parties to prepare the proposed orders, what percentage would that be?
She would offer everyone, so she would offer all of the parties to submit a proposed order. It wasn't a requirement, but she would offer that they, or extend it to them. So probably 90%, 100%, pretty high.
So So you would receive proposed orders in 90 to 100% of these cases?
Oh, is that what your question was? How many? You said how many? If I had to assign a percentage to the number that Judge Williams asked.
I'm sorry. How many or what percent would you say that you actually received proposed orders in?
Maybe about 80%.
80%, okay. When Judge Williams would come to you and ask you whether or not you had completed a proposed order for her review, and your response was no, I haven't done it yet, would she then set another deadline for you to complete it by?
Sometimes, yes.
Okay. And did she often follow up with you when she set those subsequent deadlines?
Yes.
Okay. And were there occasions where even with the subsequent deadline you had not done it?
Yes.
And what was her response in those situations?
She may ask me why, what else was I working on. She would express disappointment. It might be a reprimand, a verbal reprimand.
How soon into your employment did the issues with you getting behind on proposed orders begin?
I don't know if I could give that, maybe 6 to 8 months.
And then the memo that was discussed on direct, that was essentially a plan of action for how to address some of the issues that you were having. That was, the date on it was March 14th of 2022, correct?
Yes.
And there continued to be issues after that memo. Is that fair to say?
Yes.
Okay. But you remained employed with Judge Williams for nearly a year and a half, or over a year later, after the issuance of that memo.
Yes.
The hearing panel has seen some of the chains of emails from lawyers who were reaching out to the judges' chambers repeatedly asking for orders, and I believe you testified that people would call and send emails, correct?
Yes.
Okay. How often did you share those emails with Judge Williams?
It depended on, it just depended. It might be a weekly update, but it may not be just a forwarding of the email. It just would be in our follow-up meeting or follow-up, touch point that something was, the Brown people have called again or inquired again.
Okay. And it's true that in many of those circumstances, the order they were inquiring about was actually being worked on by Judge Williams, correct?
Yes.
Moving to a different issue, it was touched on during your direct that there were certain cases that were identified and pulled from the Mass JO calendars, and I just want to make sure I clearly understand. So you mentioned some of those cases would be where there were allegations of abuse with children, high-profile cases cases involving government officials and cases involving TV personalities, correct?
Yes.
Did Judge Williams identify those sets of cases as ones that should be pulled from the Mass JO calendar?
It would be probably a combination of staff identification, like once something had to be filed for us to know, or the parties would have to reach out for us to, or send a courtesy copy of something that had been filed for us to know subject matter or parties involved, or the parties may have reached out to ask for the case to be, for them to be able to file under seal or for it to be closed. So in that communication, it would be staff say this, let Judge Williams know what's happening, and then she would make the determination.
What was the procedure for sealing the records?
A process, the parties would have to file a request, and then we would have to get the clerk's office involved in either the case being sealed or certain documents being filed under seal.
There wasn't a hearing before they were sealed?
No,
Is that appropriate?
I don't know. I don't know that a hearing had to be held. If a party filed a request for something to be sealed, sometimes it might be a joint request, or sometimes if there were an objection, I don't think there would need to be a hearing unless there was an objection from one of the parties.
So were documents and cases sealed without a hearing during your time as Judge Williams' staff attorney?
No. Well, you're saying without a hearing. Documents may have been sealed. But it would be at the request of the parties, and there would be some communication with the parties about it, either by email or they're submitting a proposed order.
Well, of course, the parties asked. You didn't wake up and decide to seal the record. The parties wanted it sealed, correct?
Sure.
And you're not familiar that there has to be notice to the public and a public hearing before you seal a record?
I don't know that.
Okay.
Maybe that's something that I knew at the time, but I don't know that now.
Did y'all have hearings on sealing records? To Commissioner Hyde's point?
It might be something that was, okay, maybe I'm confused about what a hearing is, but it might be something that was discussed with, or what you all are saying as a hearing. It would be something that was discussed with the parties, maybe at a status hearing, or status conference, status hearing. There was not a sealing of documents. Generally, Judge Williams requested for, there have been some cases that were sealed, and it would be difficult for us to maneuver the cases, because if they were sealed, we didn't even have access to them. Judges' chambers should have had access, but there was some glitch in the system that we might not have access to, so we couldn't maneuver through the case. We would have to request for it to be opened, for us to, look at documents, whatever. So if a document were, or if a case were going to be sealed, or there was a request from a party to seal, like they may say, I want to file this, separation agreement under seal because of the financial disclosures that the parties have, or that's something to that effect.
Isn't that true on all of them, though? Why would you mentioned celebrity type people, so why would their records be treated different than the pulp water from Hazelhurst?
Okay, so the parties would be requesting for this to be done.
I understand that.
And you're asking why would the parties request it?
No, I'm asking why would you allow it to be sealed?
So what I was saying before you interrupted me was that what I was trying to explain was that judge would ask for the parties to submit either a motion or some statement saying why it should be done.
I understand that.
And so you're saying, why should theirs be done over someone else's? That's generally what she would be trying to determine.
Did she
What-
make findings of fact in a written format? Findings of fact and conclusions of law in some sort of written order before issuing an order to seal? Did you ever draft any such order?
I did not draft it, not to my knowledge, but not. I don't remember particularly, because I only think there were a couple of occasions in which that happened. But there would have to be an order in order for it to be done, because the clerk's office required an order.
Did the clerk require a public hearing also and notice?
That I don't know.
Ms. Bowles, here's part of my confusion. There's a set of local rules that governs the Family Division of Fulton County Superior Court, correct?
Yes.
Okay. Did Judge Williams have you all read these and become familiar with them?
Yes.
Okay. There's nothing in these rules that says that abuse allegations with kids, high-profile cases, government officials, and TV personalities should have their cases pulled from the Mass JO calendar and heard by the judge, correct?
I don't know. I didn't memorize the rules, so I don't know if that's there or not.
Okay. Would you be surprised to know that there's nothing in this set of rules about that?
Okay.
Would you be surprised to know that there's nothing in here about that?
Would I be surprised? No.
Okay.
But I think Judge Williams did it based on her discretion and her, just her discretion as a judge and just protecting the citizens. I don't know that every action had to be in that family rule, in the family rules.
Okay, so she selected the people that, according to you, using your words, that would be protected, correct?
No.
Well, who made the selections?
She did not necessarily select them.
She selected the classes of people.
She identified what cases, what fact patterns, what information from her judicial discretion as to what might happen.
Okay, and then you, as a member of the staff, would look over pleadings and read their substance, and that's how the determination was made. If one of these pleadings meets one of these categories that Judge Williams has set forth, then we'll pull it from the calendar that everybody else has to go on, and they get to go before Judge Williams.
No, and oftentimes a request may be made by the parties. So
Okay.
no,
So I'm not
a
talking
combination
about,
of.
I'm sorry.
It would be a combination of ways that we could determine it.
Okay, I'm not talking about when there was a 1004 filed, right? 1004 would be the request filed by one of the parties asking that the elected judge hear the case, correct?
Right.
I'm talking about situations where that was not filed.
Well, ultimately, in Judge Williams, the case track would go, unless the parties resolve their case before every 120 days, every case that was still pending for 120 days went before Judge Williams.
Okay. You indicated that the first time you reviewed these formal charges was in May, around the time you were contacted, correct?
Yes.
You testified on direct and were asked about it a number of times about the fact that you were not interviewed during the course of the JQC's investigation. So I'd like to know whether you were aware that Judge Williams came in and gave an interview to the investigative panel in May of 2022.
I'm thinking. I do know that she did have communication. I don't know if I know the date. Or that she had an interview.
Would it surprise you to know that she denied using the word soror or referencing something being on the shield during the course of that interview?
Would I be, say it again?
Would you be surprised to know that she denied those things during the course of the interview with the investigative panel?
Would I be surprised that Judge Williams denied those things? No.
And you've testified to the hearing panel today that I believe we finally settled on you did not speak with Catherine Franklin when she called on October 18th of 2021, correct?
Yes.
And you don't know who in Judge Williams' office spoke to her, correct?
I don't know. Well, no.
How many people were on Judge Williams' staff at that time, that day, October 18th of 2021?
3?
And that was you
Yes.
and who else?
Will Williams,
Okay.
Soraya. I think her last name is Ward. I don't remember if that's her last name, but Soraya, who was the judicial assistant.
So there were only 3 people back in the chambers at the time, but you don't know who is the one who spoke with Ms. Franklin.
I'm pretty sure. I don't know for certain, but I believe it was Soraya.
You testified on direct that Judge Williams, well, actually, you testified that you believe that phone call was about 10 minutes long, and I'm meaning the phone call between Judge Williams and Brandy Alexander on October 18th of 2021, correct?
Yes.
About 10 minutes long, okay. Were you in your office the entire time?
Yes.
Okay, and where was Judge Williams for the entirety of the phone call?
Also in the office, in the chambers, so between her door, my door,
And was she there for the entire phone call?
as far as I know.
So she was between her door and your door for the entire 10-minute-ish phone call with Miss Alexander.
As far as I know.
And you testified that you never heard her use the word soror, correct?
Soror, no.
You never heard her reference the fact that Miss Alexander was her sorority sister, correct?
Correct.
You never heard her use the term on the shield, correct?
Correct.
Based on the fact that you've testified that, or you said as far as you knew, she was standing between her door and your door for the entire phone call, that means that you would have heard all of the things that Judge Williams said to Miss Alexander during that call, correct?
Unless the call lasted longer than 10 minutes, yes.
So is it possible that she referenced the fact that she and Miss Alexander were sorority sisters and you did not hear it?
Maybe.
And is it possible that she referenced something being on the shield and you did not hear it?
I doubt that very seriously. That's not the language that she uses.
So it's possible she referenced the fact that they were in the same sorority.
Because it's okay for you to say I'm in the same sorority. That's not an uncommon, and I don't know that, it's not uncommon for, if you and I are in the same sorority, that I would say something about the sorority. But what doesn't follow in my mind, about the on the shield and all of that, that's not how Judge Williams taught. But could she have said soror or could she have said sorority? But she may have been talking about something else, about them being in the same sorority. So that's where the possibility. You said, is it possible? Yes.
And you testified that you did not say to Judge Williams, hey, you shouldn't call her, couldn't that be an ex parte communication, correct?
I did not say that.
You testified on direct that you also did not hear Judge Williams inquire of Miss Alexander about whether she wished to call Miss Franklin to let her know about the plan they had discussed, correct?
Correct.
Is it possible that that was said and you just didn't hear it?
Could be.
Did you hear Judge Williams reference the fact that she herself was divorced during that phone call?
No.
Is it possible she could have made that reference and you didn't hear it?
Possible.
You mentioned, I believe it was in response to one of Mr. Hyde's questions, you mentioned that there were occasions where you did draw up a notice or notify parties of ex parte communications, correct?
Yes.
Okay, can you describe some of those circumstances for us?
If one of the litigants would reach out. So we had sometimes litigants that would email us without including other parties in the case. So that was ex parte communication. Or sometimes people may call and we would, let them know we could not communicate with them something other than what time is my hearing or what's the Zoom link.
And in those circumstances, was there actually something you were drawing up or were you just sending an email to all of the parties to let them know?
When you say drawing up, what do you mean?
Was there some kind of disclosure document that you were drawing up and preparing? Or were you just simply sending an email to say, hey, everybody involved, this communication occurred and I wanted to make you aware?
Email.
All right. You were asked about Exhibit C2, which is the chain of emails that you reviewed during your direct examination testimony. As a result of the email correspondence contained in P2, and the fact that you were copied on that email by Mr. Williams, and he directed the parties to speak with you, did you ever respond to the parties after this series of emails to let them know what Judge Williams, according to you, did you ever respond to the parties as a result of the chain of emails in P2?
Did I respond to this October 28th email that said Ms. Bowles will respond at her first opportunity?
Yes.
I did respond, yes, when they got the hearing notice. When they got the notice of the hearing being reset.
Okay. And
Or they got the scheduling of the temporary hearing and the status hearing.
okay. And what was your response?
I don't know. They would have been notified about what the hearing date was.
Okay. But it was apparent based on this set of emails that your notification had never occurred. The notification to the parties that the case had been pulled and moved to another calendar, and the notification to the parties that the judge had spoken to Ms. Alexander, correct?
As of October 28th, it had not occurred, yes.
Okay. And did this string of emails not remind you that, oh my, I had forgotten to communicate with these people about what the judge asked me to communicate about? Let me do that now.
It potentially could have if that were the only email I got that day.
But there was never a response to the parties to include the information that you testified Judge Williams asked you to include.
Correct. You're saying, should the email have reminded me? Yes, it should have. Did it make me complete the task at that moment, stop and what I was doing to complete the task at that moment? No, it did not.
There was not a 1004 filed by the parties in the Carrie Alexander case, correct?
Not to my knowledge as I sit here right now.
You testified on direct that Judge Williams learned that you had not communicated what she had asked you to communicate to the parties. She learned that that had not happened when the parties had appeared in court and it came up, correct?
Yes.
Okay. And that would have been, does the motions hearing on December 14th of 2021 sound correct?
It would have been December, yes.
Were you aware that Judge Williams failed to disclose her communication with Ms. Alexander during that hearing?
I've seen some email or writing about that.
So are you aware that Judge Williams did not disclose the fact that she had the conversation with Ms. Alexander on the phone to the parties at the hearing on December 14th of 2021?
No, I thought that was part of the conversation. I thought that was part of the discussion that day.
Okay, which would make sense because that's, according to you, that's when Judge Williams found out that your communication had not occurred, correct?
Yes.
Okay. If I could have just one moment, please.
Sure.
One more question, Ms. Bowles. There were some outstanding orders in cases in which hearings had occurred prior to you beginning as Judge Williams' staff attorney, correct?
Yes.
Okay. Were you responsible for completing the orders for the hearings that occurred prior to your employment with Judge Williams?
No.
Who was responsible for completing those orders?
Judge Williams was responsible for ultimately completing all the orders.
Okay. But the ones on the hearings that occurred before you started, those were being done by Judge Williams, correct?
Most of them were worked on by her, yes.
Okay. All right. That's all I have.
Anything else?
Yes.
Ms. Bowles, there was some confusing testimony about the sealing of cases. And I just want to be clear, you've never known Judge Williams to seal any cases, have you?
No, it's done by the, it would be done by the clerk's office, but that was not a practice that she wanted to, she didn't like for the case to be sealed.
Okay.
When you say she didn't seal records, you mean she didn't put it in an envelope and put tape on it and seal it? Did she cause a record to be sealed?
There were some documents, some pleadings that were sealed, yes, that we had to take to the clerk's office in a sealed envelope with tape on it, yes. But I don't know if that was based on an order from judge or if that was how the case originated when it was on the on her family law docket.
Okay. If Judge Williams says she's never caused any cases to be sealed, would you have any reason to dispute that?
No.
I'm not sure if we got clear earlier whether you know Brandy Alexander.
Know her, I know who she is. I don't have a,
In what context or capacity do you know Miss Alexander?
I knew that she was a guardian ad litem on cases and a litigant.
Okay. And do you know whether guardian ad litems are allowed to have ex parte conversations with the judges?
Yes, I believe they are.
Okay. So there wouldn't have been anything odd about Judge Williams having an ex parte conversation with with Brandy Alexander in her capacity as a guardian ad litem?
Correct.
Okay. Now, Ms. Bowles, before you started with Judge Williams, did you tell her that you had reached out to another staff attorney to help you put systems in place?
Yes.
Okay. Who was that?
Who was the staff attorney?
Well, had you done that?
Yes.
Okay. What else did you do to prepare yourself for taking on the role of a judicial staff attorney?
I asked Judge if I could, because I knew that the staff attorney that was starting before me would be leaving. If there was an opportunity for me to shadow in any way or gain some information about, her process and the procedures that she used prior to. So I actually did volunteer a week in advance, at least a week in advance, because I had not started, so I wasn't hired I was hired, but my start date had not come. So I reached out just to try to get information in that regard.
Okay. So there was a period of time where you and Ms. Bush overlapped while you were learning the job?
Yes.
Okay. Did you do anything else to prepare yourself for the role of a judicial staff attorney?
No. I don't know how one might prepare themselves to be a judicial staff attorney in Fulton County Superior Court Family Law Division.
Why do you say that?
Because of the sheer volume, and the volume is like nothing I've ever seen before. And in other counties where I practiced years ago, and I can't imagine that the other counties have judges. All of the judges, I guess, on the Superior Court hear family cases. It's not just limited to 4 judges. In Fulton County, it's limited to 4 judges. So it's a huge volume of cases split between 4 people, and it's just an amazing amount of work and volume that everyone, all of my staff attorneys at the time spoke about, oh my God, best wishes, hope all is well, we dread family, nobody wants to be in family, because of the volume.
It wasn't a prerequisite to being a staff attorney for Judge Williams or any other judge to have been a staff attorney somewhere else, right?
Correct.
There was some testimony about you not recalling being told about a statute about. There was some testimony. Yes. Let me ask a better question. There was some testimony about a 90-day rule for needing to issue orders on after hearings, not within 90 days of a hearing. You recall that testimony?
Yes.
Did the judge ask you to provide her with proposed orders within 2 weeks of a hearing?
Yes.
Now, when you did not draft a proposed order, or the parties had not presented a proposed order, would Judge Williams sometimes draft the order herself?
Yes.
Okay. You've known her to do that?
Yes.
How often?
Pretty regularly. I mean, percentage-wise or very often.
Okay. Pretty regularly would do?
Yes, pretty regular.
Have you known, in your time with Judge Williams, did you know her to just sign a proposed order that had been submitted to her?
No, never.
Did you know Judge Williams to have signed a proposed order that you drafted?
Not to just sign it, anything that I drafted, no. She was very thorough, very meticulous in everything that was written. So no, even after there, it may be a couple of edits of something that I had drafted, but no.
Okay.
She did not rubber stamp.
All right. Okay. You were asked about the memo that I showed you, I'll call it a performance improvement plan memo, just for short. That you discussed with Judge Williams in March of 2022. Do you know if Judge Williams was dealing with her mom getting cancer around that time, or anything going on in Judge Williams' personal life?
I do know her mom was diagnosed. I don't remember the time frame, but we unfortunately experienced a lot of personal family issues collectively as a staff during that time. Like my father passed in June of 2022, and after being bedridden for 6 months, 2 months into my employment beginning, and then Judge's mom was ill, her grandmother was ill, so I don't remember the exact time frame, but unfortunately there were a lot of illnesses and deaths that we were dealing with.
Did you talk with Judge Williams about her interview before the JQC investigative panel?
I don't think we spoke in detail. You mean the 1st of May or something, May 2022 timeframe?
Yes.
She didn't talk a lot about it, no, while we were there.
Do you know anything about the contents of that interview?
No,
You haven't read a transcript or anything?
no.
Knowing Judge Williams as you do you believe Judge Williams used the word soror or on the shield with Miss Alexander?
I do not.
And you've never heard Judge Williams talk to a litigant about being in the same sorority, have you?
I have not.
Okay, that's all I have. Thank you.
Anything else for this witness?
No, Your Honor.
All right, may we excuse Ms. Bowles? The objection?
No objection.
Thank you, Ms. Bowles. You're free to go. Next
Thank you.
witness.
Judge Williams will call Ms. Heather McCann.
Okay.
Mr. Banks, how many more witnesses do y'all intend to call today, and what?
We have 2 witnesses that are here, and I think Ms. McCants is going to be a fairly short witness. I don't intend for her to be long. Brittany Green, Judge Williams' current staff attorney, is the next witness. She may take a little longer. Maybe about an hour.
We're right at 4 o'clock right now. And
Yeah. I'm happy to.
it's unlikely to get through both today.
I don't disagree with that. I don't disagree with that. Ms. McCants, can you please raise your right hand? Do you swear or affirm that the information you give this hearing panel shall be the truth,
Yes, I
the
do.
whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you can have a seat.
Thank you.
If you could make sure that you speak into the microphone so that everybody can hear what you're saying.
Absolutely.
Good afternoon, how are you?
I'm well, thank you. How are you?
Can you please spell and state your name for the record?
Sure. Heather McCants. It is Heather. McCants, McCant, T as in Tom, S as in Sam.
And Ms. McCants, how are you employed?
I work for Fulton County Superior Court.
And how long have you been so employed?
I started my tenure with the court in August of 2016.
Okay, and tell the hearing panel, if you will, what capacities that you, and what roles have you had there at the court?
Okay. Yes, I started in August 2016 as the Human Resources Manager. And from there, I transitioned to the Deputy Director of Human Resources. And right now, I serve as the Deputy Court Administrator for Business Services and Infrastructure.
Okay. Prior to working for Fulton County, what did you do?
I worked in Human Resources I've been in Human Resources for about 25 years.
Okay. Can you tell the hearing panel what your role and responsibilities are as the Deputy Court Administrator?
Yes. I am responsible for the human resources function of the court, meaning I hire onboard employees. We are responsible for recruitment, payroll, things of that nature. I also am responsible for the financials, meaning that we support the 20 judges with regards to their budgets, as well as purchasing, procurement, things of that nature. I also am responsible for court technology, and we assist in the administration of court technology for the court, for our 20 judges.
Okay. How often do you interface with the judges on a day-to-day basis?
It just depends on their needs. So I interface on it could be one judge per day, or it could be 5. It just depends on what the needs are at the time.
Okay. A lot of different personalities, would you say?
Yes, absolutely.
Fair enough. Who do you directly report to?
David Summerlin, the court administrator.
In your capacity, in your work experience with Fulton County, have you had the opportunity to work with Judge Williams?
Yes, I have.
And how closely have you worked with Judge Williams?
I work with all of the new judges. So as they come on board, I have more of an opportunity to work with them, getting them set up with their budgets and going over that information with them, ordering supplies, things of that nature. So when Judge Williams took the bench, I had the opportunity to work with her directly.
Okay. Based upon your professional observations and working with Judge Williams, have you been able to develop an opinion concerning her professionalism?
Oh, absolutely.
And what is that opinion?
She's fun to be around, very jovial person, very professional, and very understanding.
Have you developed any opinions about her work ethic?
Yes.
And what is that opinion?
That she's very diligent in what she does. We have a saying in the court, sometimes some of the cars stay out in the garage a little bit later, and we know a few of the judges who are always going to be there late, and I know Judge Williams' car is often there a lot late.
Okay.
So,
right. Were you around when Judge Williams took the bench in January of 2021?
yes.
And at some point, did you join her with her at her chambers when she took the bench?
Yes.
Were you there? Did you develop an opinion as to whether or not she had everything she needed to perform the job when she first took the bench?
Yes.
Okay, and what was that opinion?
She needed office furniture.
Okay. There's been some testimony that she didn't have any office furniture in her individual office, and I'm not going to belabor the point, but, did you see that firsthand based upon your observations?
Yes.
Okay, and what did you observe specifically?
She just had her credenza and a chair.
Was that unusual for you?
She was the first judge that I've seen who experienced that, but I'm not involved in that process, but I would say it would be unusual.
Who would have been responsible for that?
It would have been Mr. Summerlin, and we have another deputy court administrator who would have walked the office to make sure that furniture was in the office.
Or not?
Or
make
not
sure that
there.
it's not there.
Correct.
Were you able to see Judge Williams' reaction when she got to the office and didn't have any furniture?
I did not see it that day. I saw it on a different occasion.
Okay, and what was that reaction?
It was a bit of disappointment.
Okay, all right. I want to turn next to any staffing challenges that you may have been aware of. At some point while working closely with Judge Williams, did you determine that she had some staffing challenges as a part of her chambers?
Yes.
And how did you become privy of that?
She reached out to me.
Okay. One of the staffing challenges, did that involve Janelle Bowles?
Yes.
Okay. When did you first learn, if you recall, about learning about the staffing challenges that Judge Williams had with Mrs. Bowles?
I don't recall that.
Okay. You said the judge first approached you. You just don't recall when it was?
It was probably around April, May-ish, but I can't be certain. I can't be certain of the time.
What specific concerns did Judge Williams express to you, and what did you do to assist her in those staffing challenges?
Well, as most judges do when they have staffing concerns, they call to kind of just as a sounding board because for the most part, chamber staff are personal staff of elected officials, and so they kind of have latitude in terms of who works for them. And so we typically just listen and give advice on what the policy says, even though a lot of policies that are in the county they are exempt from, but we just give them advice on the particular issue and what could be done.
Okay. Did she express to you specifically what issues she was having with Janelle Bowles?
Yes.
And what were those issues?
Lack of follow-up, things not getting done in a timely manner, and just the overall ability to keep up with the work.
At some point, did she discuss with you a plan of action as to how to deal with what I would characterize, if you will, the deficiencies of Mrs. Bowles?
Yes, she did.
And what were, I mean, do you recall her plan of action and what steps she took to correct those measures?
Well, not specifically. We talked a lot about what they would do. Kind of, okay, they would have this process where they would walk the docket of sorts and look at everything and make sure, things were getting moved. And she thought that was happening, and it just did not happen like she thought it was happening. And so that was the extent of the conversation in terms of, following up in an email saying, hey, did you do this? And, just that back and forth, but never anything concrete to me.
How many times, give the hearing panel an idea of how many times you spoke to Judge Williams about the staffing challenges she had with Ms. Bowles?
I would say about maybe like 2 or 3.
Okay.
Yeah.
Do you believe that her initial plan of action, when she first approached you concerning some of the deficiencies she discussed, do you believe that her plan of action was appropriate at the time?
I think I would have moved a little quicker.
Okay, you can speak
personally.
I know she's here, but you can feel. I mean, do you believe? Why do you feel like you would have moved quicker?
Because of the gravity of the cases that we and the work that we do every day. I think it's important that things are done on time, and things should have been done in an orderly way. And so I think she should have moved a little bit faster, but she wanted to give a little grace in, knowing that everyone has issues or things of that nature. She wanted to give her a little bit more grace. I probably wouldn't have.
Okay. Did you develop an opinion as to why she was extending so much grace to Ms. Bowles?
Yeah, I think.
And what is that opinion?
I think she wanted everyone to be successful. I think she wanted it to work. She wanted her to be able to get it. She wanted to give her an opportunity to be successful.
You were a part of Ms. Bowles' onboarding process, were you not?
Mm-hmm.
At any point did you have you didn't participate in an interview, did you?
No,
Okay. There were no difficulties with her being onboarded, is that true?
not to my knowledge.
Did she satisfy the qualifications of the job description that was posted for the vacancy that Judge Williams had in her office?
Yes.
Okay. Do you know how Judge Bowles got to, I know she applied, did anyone have any recommendations on behalf of Judge Bowles, and did those recommendations weigh on Judge Williams when she made a decision to hire?
Well, I think she was recommended by another judge.
Okay.
Mm-hmm.
All right. At some point, did you speak to Judge Bowles, for crying out loud. Did you speak to Mrs. Bowles about her performance issues with Judge Williams?
Yes, I did.
And on how many occasions?
She reached out to me, I think, on 2 occasions, but I only met with her in person on 1 occasion.
When you met with her, do you have an impression as to whether or not she was qualified for the job?
No, I don't. I think that wasn't the gist of our conversation when I met with her.
Okay. Did she talk to you about some of the performance issues that she was having in chambers?
She did.
And tell the hearing panel what she expressed to you.
Well, she said it was just way too much. And she had never worked like that in her life. And it was overwhelming. And she had begun to not like people because it was just constant litigant emails, phone calls. It was just a lot.
Did she ever tell you that she dropped the ball on many occasions?
She did.
Did she ever tell you that she would tell Judge that she completed some tasks but hadn't completed the task?
She did.
Did she also share with you some of the personal experiences or personal issues she was having on the job that impacted her ability to perform?
I don't recall personal.
Okay. At the time that you spoke to Ms. Bowles, did you ever reach back out to Judge Williams about that conversation?
I believe so, because at that point, Ms. Bowles had already tendered her resignation.
Okay.
So,
Was it a forced resignation, or did she just decide to go in a separate direction?
I'm not sure.
Okay. Did you have a conversation with the judge about that?
I don't recall.
This was Judge's first time on the bench, you agree, from January 2021?
Mhm.
That was her first term?
Right.
Is it uncommon for new judges to have staffing challenges in your experience?
No, it's not.
Okay. Are you aware of any staffing challenges that currently exist with Judge Williams in the present?
No, I'm not.
Have you, in light of her prior staffing challenges, have you talked directly with Judge Williams about her new staff and whether everything was working well?
Could you repeat that?
In light of her challenges with Ms. Bowles, have you since followed up? Because she's made some new hires, has she not? She's hired Brittany Green, true, and she's hired some other staff to
Right.
assist her. In light of the prior staffing challenges that she had with Ms. Bowles, have you followed up with Judge Williams to determine whether or not those staffing challenges have been resolved and are no longer?
No.
Okay. Has she complained to you about her current staff at all?
No.
Have any of her current staff, come to you and express problems or concerns about their ability to do the job?
No.
Okay. If I can just have a moment real quick. That's all I had. Thank you.
Okay. Any questions for this witness?
I don't have any questions for you, Ms. McCants. Thank
May
you.
we excuse Ms. McCants?
Yes.
Okay, thank you. You're free to go. Thank you. All right, hang on a second. All right, I think we could probably go for about another 30 minutes, ending around 4:45. So do you want to go ahead and put Ms. Green up and see how far we can get if she's here?
I think so.
Okay, well, let's get about 20, 30 minutes under our belts, and we'll just pause at about quarter of. We'll have Mr. Parmar sound the alarm at 4:45, okay? Just, you can be our timekeeper over there. Probably.
I know who she is.
Right. Mayhem.
Can I take credit for that?
Good afternoon.
Good afternoon.
We're going to swear you in before your testimony. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Would you please state and spell your name for the record?
Brittany Green, Brittney, Green, Green.
What do you currently do, Ms. Green?
I am staff attorney for Judge Williams.
How long have you been in practice?
Going on 10 years now.
How long have you been a staff attorney for Judge Williams?
Going on 2 years. I started in July of 2023.
Prior to becoming a staff attorney for Judge Williams, what did you do?
So I was a child support attorney, and then I did private practice. So I did divorces for 2 firms, and I was also a guardian ad litem.
Prior to you joining Judge Williams as a staff attorney, was there a gap at all in Judge Williams' staff attorney role?
I believe there was.
How long?
I am not sure. I know that when I started, she did not have a staff attorney.
Do you know how the work of a staff attorney was being done before you started?
Either Judge Williams would do it, or there was a floating staff attorney that was there when I started.
How did your prior work in family law prepare you for your role as a staff attorney?
It prepared me because I knew how divorces, custody, those matters, how they moved along. I was familiar with the area, so it prepared me for the role.
How long did it take you to get up to speed in your new role as a staff attorney?
It took me a while to be comfortable in the role. I will say it took me maybe 4 or 5 months to get completely comfortable with the task and the things that I should be doing.
Was it coming from life as a practitioner? How did your work as a staff attorney compare?
I mean, night and day. When I came into the role, there was a large caseload, and previously my caseload with the other firm would be, 30, 40 cases. So I'm coming into a larger caseload and more tasks and responsibilities.
What do you mean responsibilities?
Just, managing calendars, scheduling hearings. I didn't do that with my previous employment, so that's something new that I had to do becoming a staff attorney.
Were there any special challenges with litigants?
What do you mean by?
From the judge's side of the bench, dealing with parties and litigants?
Dealing with people who are self-represented, helping them along the process,
it's hard because, they're asking for help and we can't give legal advice, handling attorneys and, the emotions of, a domestic case.
When you joined Judge Williams as a staff attorney in July of 2023, how would you describe the state of her docket?
It was large. There were hearings that needed to be scheduled. She just had a large docket.
How did you go about attacking the large docket?
It took me time. When I started off as a staff attorney, I reached out to other staff attorneys for judges who were in the family bench to kind of get an idea of how they're managing their caseload. But ultimately, it was up to me to figure out how to come up with a system that made sense for me to get a grasp of the caseload and how to make sure the cases move forward.
But wasn't there a system already in place when you joined Judge Williams' staff?
There was a system, but I needed a system that made sense for me to make sure I was keeping track of the cases and how to move the cases along. When I started, there was a manual that I think Tangi had made that helped me with, the beginning processes. But in order for me to be organized the way I like to be organized, I had to come up with my own system.
Did you create some kind of spreadsheet?
Multiple spreadsheets.
What kinds of information do your primary spreadsheets contain?
I had different spreadsheets, but ultimately what I did was when the case was initiated, the type of case, the last time the case had a hearing, if there were any pending motions or any pending issues, those would be listed on my spreadsheet.
Would you specifically track for any orders that were approaching being 30, 60, or 90 days past the hearing?
So I had a spreadsheet, I had a orders spreadsheet, and so I would review that spreadsheet constantly to ensure that the orders were going out as they needed to go out.
Was it your understanding that an order needed to be filed within 90 days of a hearing?
What do you mean by
within 90 days of a hearing on any motion, should a hearing have been required?
Can you ask that question again?
Sure. Are you familiar with a statute that requires orders to be filed within 90 days of a hearing on a motion, assuming a hearing was required?
Yes, I'm familiar with the statute.
Okay. Did your spreadsheet track against that time period?
It did not, but I had a self-timer to ensure that the orders would go out in a timely manner.
Does Judge Williams have any standards for ensuring that orders go out in a timely manner?
Yes.
What are those standards?
When I first got the role, she explained to me what my tasks and my duties were, and it was the understanding that if an order was not done by the attorneys, it was my task to draft that order and get it to her within 30 days.
Do you do that?
Yes.
To your knowledge, are there currently any orders that are outstanding past 90 days of a hearing?
When you say currently, you mean with the general docket or?
Fair question. So my understanding is that Judge Williams is no longer in family, right?
Correct.
Okay, I'll ask you about that separately.
Okay.
So the questions I'm asking you now are about family.
About family, okay.
Yes. So by the time you left family, was it December 2024?
Yes, so the last day was December 31st. So January 1, we switched over to the general docket.
Okay. So as of December 2024, are you aware of any orders that were more than 90 days past due?
No.
These systems that you instituted, did you create them on your own?
Yes.
Okay. And did
Well,
you,
my spreadsheets, I created my own spreadsheets, which were my systems.
right. And did Judge Williams help you create those, or she simply just told you what her expectations were and you went off and created the systems?
There was a spreadsheet that I looked at, and I kind of tailored it to that and made it to where it made sense for me, and then eventually worked off the spreadsheet that I created.
Thank you.
What is Judge Williams' role? Is she actively involved in ensuring that orders get out in a timely fashion?
Yes.
Okay, how so?
We have, I guess you call it case management meetings. You know, we'll run the docket every so often. We'll talk about cases. I'll print off the orders list for her to take a look at, and so we're constantly talking about cases.
Let me ask you about Judge Williams' caseload when you started in July of 2023. Are you familiar with this document?
Yes.
Okay. Well, do you review this document on a regular basis?
Not on a regular basis. We get them once a month, so when we do get them, I do look at them.
Okay. Do you do anything with it? Do you take any action?
So yes and no. So I look at it. We look at it to make sure that the numbers match the reports that we run as well, because we run our own reports to make sure that the numbers add up to the same numbers that we have on our own reports, because they don't always match.
Okay. Do they match within, say, 10% of the accurate numbers?
It depends on the month, but yeah.
Generally?
Generally. I mean, a couple reports they'll have to rerun because the numbers are off, but for the most part, it's a good gauge to see kind of how different our reports that we run and the reports that we get monthly.
Okay. So as of July 2023, Judge Williams started with a pending caseload of 742 cases. You see that?
Yes.
You got in 93 cases, just going by the new cases column, and disposed of 82 cases. Do you see that?
Yes.
Okay. Do you have a target that you try to hit in terms of disposing of cases?
So when I got comfortable in my role, my goal was always to dispose of 100 or more, just knowing that in any given month we'll get over 100 new cases. So really just trying to bring down that caseload.
Okay. That last column, pending greater than 18 months, that doesn't refer to orders, does it?
No.
Okay. In this case, there are, I'll represent to you, 16 complaints about failures to rules, delayed rulings, I should say. I'm not going to ask you to do any math.
I'm not good at it.
Okay. On average, and I don't know that this particular month that we've pulled out is representative, so you've got 16 complaints on delayed rulings. On average, how many new cases do you get in a month?
Over 100.
Okay. And you dispose of, on average, how many a month?
Over 100.
We've heard, the hearing panel has heard information about emails, the large volume of emails that are received in family. What's your practice with respect to reading and responding to emails in family?
In family. We get a large number of emails, and, I do my best to respond to each one of them. So I typically respond either 24 to 48 hours, just depending on if I'm in the middle of trial or if I'm out of town. So I do try to be as responsive as I can.
Let's just look at the end of your team's term in family, which testified was December 2024. How are you doing as of December 2024 in terms of your caseload?
We got it down significantly.
So You, in terms of the ending pending caseload, you're at 536
Mm-hmm.
and 18 matters in the pending greater than 18 months.
Yes.
How do you feel about those numbers?
I was ecstatic.
Why?
Only because when I came into the office, my goal was to get it under 550, and so it was always my goal to get the cases under a certain amount. And so, just meeting that goal just brought me pride.
Okay. And how did Judge Williams react to meeting that goal?
Yeah, I think we were all just ecstatic and just we worked really hard to get these cases disposed of and moved along. In family, they're not all cookie cutter, right? You have some cases that take longer. You have cases dealing with psychological evaluations, galls, custody issues. So they're not all going to be disposed of within 12 months, 6 months. Some just take a little bit more time to dispose of. And so, I think that I just want the panel to understand that not all cases are cookie cutter. Some just take longer than others.
What do you attribute to your success in getting the docket down so significantly?
I think just, working as a team, my litigation manager, just being focused. Like I said, my spreadsheets really helped me being organized. I pride myself on being an organized person. And so I think just being organized really helped us move the cases along.
Have you noticed any changes in how Judge Williams, as of December 2024, had you noticed any change in how Judge Williams processes orders and gets orders out?
No, because when I got there, we just came up with like a system that worked for me and her to ensure that we were working as a team to get the orders out.
The hearing panel has heard testimony that Judge Williams would do her own orders or spend significant time working on her own orders. Had you noticed any changes in that regard?
No. When I get a proposed order from an attorney, I will redline it to, what she likes, but ultimately, she adds what she thinks is pertinent in an order, and so that comes from her.
Did you experience any change in the amount of edits that the Judge Williams would have to the orders that you would present?
Yeah, the first order I did, I think she redlined it up pretty well. I was like, oh, my writing is horrible. But after, working with her and understanding what she likes, my orders that I draft have less edits than the orders that we get from attorneys.
Okay. And so that makes it makes the process of getting orders out faster.
We also implemented in our notices that I don't think a lot of attorneys read, but they are to bring proposed orders with them to court. And so that lessens me having to track attorneys down to get proposed orders or having me draft the orders themselves.
Had that been a problem in the past?
Yes. We'll have a hearing and then, counsel will ask for, time to get a proposed order. And then, I look up and I haven't gotten it yet. So now I need to either draft it myself or follow up. And so it just made the process easier to have them bring proposed orders with them to court.
And if they don't?
If they don't, she will either give them time to do it or I just draft it myself.
Okay. And when you are drafting orders yourself, what is the timeline that you have?
I get it to her within 30 days.
And then she turns it around typically within how long?
Case by case basis, depending on if it was a lengthy trial that had a lot of witnesses or a lot of facts that needed to be into it. But at least if I handed it to her, she would get it back to me no longer than 2 weeks.
Okay. So I understand now that the team is now in the general docket, so non-family.
Non-family, yes.
Okay. What's the difference? Any differences there?
Oh, yeah. So the caseload is a lot lighter. We have about 230 cases. We get in about 30 cases. And that's just for civil. We also have a criminal docket that the litigation manager handles. So I handle her civil docket, the litigation manager handles the criminal docket. And so it's just a lot less, I call it hand-holding. So I don't get a lot of emails from attorneys. Not a lot of people are self-represented, so I don't get a lot of emails. You know, you have a couple, but my emails aren't as intense as they were in the family division.
Any other differences?
The general docket, the attorneys will submit proposed orders without me even really having to ask. So I do get those timely. And there was issues with the family division where parties or councils will, e-file motions and I don't receive a copy. And so I don't know about them unless I, what we call walk the docket, which means I look at every single case that we have to see if there's anything pending. And so the general docket, most of the attorneys, they'll send me courtesy copies of the motions.
Okay.
But it's easier for me to we call it walk the docket. It's easier for me to review the docket in the civil division than it was in family.
Okay. Are you a member of a sorority?
I'm not.
What is your impression of Judge Williams as a judge, as you've come to know her over this past year and a half or so?
Yeah. In my opinion, she's kind, she's compassionate, but she's also direct. She handles her courtroom with grace, and I think any attorney that, appears before her will say the same thing.
Do you know anything about her reputation around the courthouse?
I know that after, long hearings and trials, the attorneys will just, thank her, let her know that they had a great trial. She was great. She's fair with her rulings. And so they've always just shown gratitude after the end of a trial.
Just one moment. We were talking about the differences in processes. Does the team use binders now?
Mm-hmm.
Can you tell the hearing panel about binders?
Sure. So how I prepare for a week of court is I will print out, if it's a motions hearing, I'll print out the motions along with the proposed order and give it to her in a binder. If it's a motion that doesn't require a hearing, I will create a binder for her that has all of the motions in them along with a cover sheet, just so she knows what the case name is and when it was filed and when the motion was filed.
How does that aid in the process of getting the work of the court done?
It makes it a lot organized. So when she's done with because they're all in one binder for her, right? And so she knows to work on that one binder, give that binder back to me to make any pertinent edits or just to file the orders.
I asked you about outstanding orders in family as of December 2024.
Mm-hmm.
How about now? To your knowledge, does Judge Williams have any orders that are more than 90 days outstanding?
No.
Okay. That's all I have for now. Thank you.
Okay. Well, why don't we pause there? Are you going to have more questions for her tomorrow?
I will
you think? You'll have some questions for her, I assume. Okay, so we'll see Ms. Green back in the morning then. She'll be the first witness up. So that's where we'll pause for tonight. Thank you. We'll see you back in the morning.
Okay.
Okay, just watch your step. Thank you. And then for scheduling planning purposes tomorrow, I know we've gotten to about 4.5 witnesses today. What do we have left just for our planning purposes, and I guess the directors, if she has any rebuttal planned?
We have, I believe, we have 4 additional witnesses.
Okay. 4 including Judge Williams or 4 counting?
Four
Including.
Including Judge Williams.
Okay.
Counting Judge Williams.
Okay, so do we think we're still on track then to finish case in chief tomorrow of Judge Williams?
Yes.
Okay, and does the director anticipate having any rebuttal witnesses, or will we just be moving into closing after that happens?
We may, Your Honor, but they would be very brief if we did.
So everybody may need to be prepared to close tomorrow, it sounds like, depending on what time we stop with witnesses. So just keep that in the back of your mind. Okay, well then we will see everyone tomorrow and start at 9 again. Thank you. Oh, one question, and this we can finish the live stream. This is just a housekeeping matter. Somebody, I think it was you, Ms. McFadden, you put up a previous hearing. Is that a transcript that's already been prepared